Yeah, live, sir. Neeraj, please start.
Yeah. So, good morning, one and all present here. Honorable Vice Chancellor Sir, Pro Vice Chancellor Sir, Vice Chancellor Sir Dr. N.P. Kaushik ji, Pro Vice Chancellor Dr. Ajay Badar ji, or one of the judges, Dr. Brijender Singh Yadav ji, and Dean of Legal Studies, Professor Dr. Ramanjit Singh ji, and all the participants are, first of all, I would like to congratulate you for qualifying the first round. So before starting the proceeding of quarter-final round, the names of the team and the proceedings, how we will proceed for 2 days, another for semi-final and final rounds, I would like to invite our Honorable Vice Chancellor Sir Dr. N.P. Kaushik ji to few words of wisdom for blessing and congratulating to the quarter-final round qualifiers. So please welcome. I am giving charge to our Honorable Vice Chancellor, sir.
Okay, thank you, Taneja ji. I hope that I am audible there. I am audible?
Yes, sir, audible, sir.
Okay, thank you. Good morning, Dr. Vijender Singh ji, Director, Quantum University, Roorkee, Dr. Poddar, our Pro Vice Chancellor, Dr. Ramanjit ji, Dean, Legal Studies, Sri Taneja ji, and good morning to all and one present in the second day International Moot Course Competition. I wish to congratulate the team of School of Legal Studies and all members of organizing team for successfully completing the proceedings of first days of this moot court competition. It is a matter of great pleasure for me and the university that 24 teams from all over the country participated in the first round of competition, and now the teams are entering to the quarterfinal, semi-final, and two teams will be reaching to the final of the competition. It is also a matter of great pleasure and pride that many reputed NLUs are also participating in this competition. NLU Punjab, NLU Himachal Pradesh, NLU Bihar, and many reputed law schools and universities from Pune, Bangalore, Mumbai, Trivandrum, Delhi, Indore, and many other places from the various parts of the country are participating in this mega event. So this is really making the event a meaningful and truly competitive. I welcome all the teams and their members and wish my best wishes for the second round of the activities. It is a matter of great pleasure and proud for me and university that dignitaries in the field of law are gracing the event by their gracious online presence. I am thankful to Dr. Surya Prakash, Honorable Vice Chancellor, NLU Visakhapatnam, and Sri Abhay Ojaji, who graced the occasion in inaugural function yesterday and inspired our various teams participating in this event. I am happy to note that Professor Nista, Honorable Vice Chancellor, NLU Simla, and Professor Vinay Kapoor, Honorable Vice Chancellor, NLU Haryana, and Sri Gautam Menon, Additional Session Judge Delhi, gracing the today's event. And it is my great privilege to welcome them and also express my deep sense of gratitude to all dignitaries for accepting our invitation and making the event meaningful and also inspiring the all participating teams. I am thankful to honorable judges of this event, Sri Abhay Ojaji, and today Dr. Vijender Singh Yadavji are present in this session. So I am thankful to the presence of Dr. Vijender Singh ji and Abhay Ojaji for their gracious presence and also making a impartial judgment for all the teams. For becoming a successful lawyer, it is not only important to study the various subjects of law, but it is also important that how one prepares himself to face the real court situation, prepares a case and present it before the judge, and can prove his point in the court. The counselor also present their side in the court on the basis of evidence, substantive questions, and argument based on the facts of law and prove their point in front of the judges. Our law student also needs some kind of practice and training during their education. The competition of such kind makes the student more efficient and they learn from each other. Yesterday in inaugural session, our chief guest, Professor Surya Prakash, emphasized on two very important aspects of moot court, that is interpretation and presentation in the court or moot court. In the real situation also, these two things are very important. And Sri Abhay Ojaji, who is the judge of this event, he emphasized on the research regarding the case. So these skills are not only making the perfection in the lawyers, but also brings perfection in the personality of the self. So if one has to become a very successful lawyer, he has to take care of these three things, that is interpretation, presentation, and research about the case study. I feel that many times it is not important that we make a lengthy argument. If we present the peculiar facts and court references and appropriate law, one can prove his point, and many liars show this successful story also, that they simply quoted one line of the law and they could get the case in their favor. The moot court can be subject specific, and we must also share the case studies of successful cases or cases of our learned lawyers, because we know that the cases are uh, fought at the level of session courts, high courts, supreme courts. So we have to prepare our students for all level of courts, and therefore the successful stories and peculiar cases of these courts should be shared with our students. And I hope that such competitions are very useful in making this training of our law students. I appreciate the efforts which are made by our School of Legal Studies team and the organizing team, that they have organized such a very wonderful event. And it is first time that OSGU has organized this moot court event. Because of the COVID situation, this event has been organized in online mode, but definitely in coming future, we will organize such a kind of the event in offline mode. And it is my great pleasure that various schools of studies in the OSGU are regularly organizing such events, that is conferences, FDPs, etc. And it is only because of the inspiration of our Honorable Chancellor and Pro-Chancellor. They always keep motivating all the faculty and deans that they should organize such activities, so that we can produce a good quality of the students, whether it is in the field of law or any other field. Once again, I am thankful to all our dignitaries who grace the occasion and make the successful event and meaningful event. I am also thankful to all the teams who spared and make their effort to make this event successful. And I'm thankful to all of you. Thank you. Thank you, sir.
Thank you very much, sir, for your blessings. It's always inspiring, your guidance. So, I just let you know all the participants, judges, and all the dignitaries of from Om Sterling Global University. At 2:45 p.m., we are supposed to start our valedictory session with our respected Chancellor Sir and Pro Chancellor Ma'am and all the dignitaries from as well as Om Sterling Global University, and our chief guests will be Dr. Nishita, Vice Chancellor NLU Shimla, Dr. Vinay Kapoor, Vice Chancellor Dr. B.R. Ambedkar, NLU Sonipat, Haryana, and Gautam Menon, Additional Session Judge, वो पोक्सो के चेयरपर्सन भी हैं दिल्ली के. So I welcome virtually, I welcome them all, and now I would request to our one of the judges, Dr. Brijender Singh, Director Quantum Business School, Quantum University, Roorkee. So they will, he is supposed to give his blessings to the participants. And one more thing, sir, I would like to make in your notice that each team will have 25 minutes only collectively. So you are requested to please be strict in such norms so that we can take it in completed in time. So please welcome Shri Dr. Brijender Singh ji for their words of wisdom. Over to sir.
Thank you, Dr. Neeraj. It's really profound pleasure for me to be on board today in front of your Honorable Vice Chancellor, Dr. N.P. Kaushik ji, Pro Vice Chancellor, Honorable Dr. Ajay Poddar ji, your Dean School of Legal Studies, Dr. Ramandeep, yourself, Dr. Neeraj. It's really profound pleasure of mine to be a judge on this very prestigious international moot court competition. So I'm only to say that yes, all the best to all the surprise packets of the teams which I'm seeing, because I'm so surprised to see the wonderful teams from prestigious universities, national law universities, even you have received. So that's wonderful. All the best to all the students. I'm looking forward to have the presentations, the deliverables within the time frame as said by Dr. Neeraj. And rest, I'm hoping that the best there is nothing like best or better, but yes, obviously the little better team would go up as the topper, and let's hope for the best. The only the motto of the day in today's judging would be the integrity and sanctity of the competition to be maintained. That's may God allow me that superpower to judge the competition with a sense of integrity. So once again, thanking you all the people for organizing such a wonderful international moot court competition. I'm very much sure that this competition would bring a new heights of milestone to your university. So all the best to all the students from different universities across India, and looking forward to a grandeur event. Thank you. Jai Hind.
Thank you very much, Dr. Saab. And once again, I would request to our Dean, Professor Dr. Ramandeep Singh ji, because he is the brain and he dreamt it to make a tradition here for first international moot court competition. So I would request to our respected Dean to please open the quarterfinal round and explain the teams. Over to sir.
Good morning, everyone. I thank to all the dignitaries present over here and the judges, Dr. Yadav. To be very brief, as the students are also waiting for the start of the competition, I would just announce the teams who are participating. There are the first team competition will be between A3 and B5, that's Chanakya National Law University and Trinity Institute, Dwarka. The second will be between Punjab University Regional Center and GD Goenka University, Gurgaon. The third will be Guru Gobind Singh IP University and SRM Sonipat. The fourth one, Government Law College, Mumbai and Navratna University, Gujarat. and the fifth one Kerala Law Academy and Indore Institute of Law. So we will be going with these 5 teams, and I would request all the teams also. The total time collectively given to each team is for 25 minutes. After 25 minutes, 1 or 2 minutes taking a surplus, it will be automatically closed down, and the next team will be called. The time limit has been set out in the virtual software that is being run. After 25 minutes of time, with giving a spare time of 1 to 2 minutes, the system will automatically close that competition, that debate that has been going on, and the next team will be called as per the time schedule. As this has been done, as we have to go for the 5 rounds of the quarterfinals, then 2 for the semifinals and 1 for the final rounds also, and the complete event has to be completed by today. I again, once again, thanks our Honorable Chancellor, Dr. Puneet Goyalji, and Co-Chancellor, Dr. Poonam Goyalji, along with our Vice Chancellor and Pro Vice Chancellor, to provide such a platform where we can conduct such an event and making it out a part of the School of Legal Studies, and my complete team at School of Legal Studies, including Advocate Neeraj Taneja ji, Kush Ahuja ji, Keshav Vimal ji, Dr. Sudesh ji, to execute such a program by School of Legal Studies OSGU. I extend my all the best wishes to all the participants of the team and hope that they will perform to their maximum. Thank you very much. Over to Neeraj Taneja ji to get the event started. Thank you very much.
Thank you very much, sir. So I request to our dignitaries, they may join us or they may sign out. We will meet at Valedictory at 2:45 p.m. And I also request to our Judge Dr. Vijender Singh ji and the team members to open their, to come forward, team A3 and team B5. So, Dr. Vijender Singh ji, कितने पे 11:30 पे होना है ना, 11:30 तो हो गए यार. So I would request to B5, Trinity Institute of Professional Studies, Dwarka. Speaker 2. And their researcher as well. Okay. Team 1, Chanakya National Law University, Patna, A3. You may raise your hand.
Yes, sir, we are there, Chanakya National Law University.
And
But
Trinity Institute of Professional Studies. And your topic is human rights. Over to, where is your second partner? Chanakya A3, Team A3.
sir, she is in backstage. You have not admitted her yet in the show.
Please connect he or she, camera
Sir,
and mic.
she,
Okay.
Sakshatya A3, Chanakya National Law University.
She is also supposed to join us with her camera and mic. From B, Trinity Institute of Professional Studies. Please introduce yourself. Team B5, Trinity Institute of Professional Studies, Dwarka. I am requesting, we are very less of time. You please come forward. Come quickly.
Yes, sir. Yes, sir. Am I audible?
Yeah, you are audible, and your topic is human rights. And you know who is the petitioner, who is the respondent. Now you may start.
Sir, my second speaker is still in the backstage. She's not in the show right now.
So what
Please
to do?
And sir, Chanakya National Law University are representing petitioner side. So I think they should represent first.
Okay, you are taking as a petitioner first, and she is taking respondent. And
Yes,
your
sir. Our
side,
university, our
your
college
side
is
is
representing the respondent side, and they are representing the petitioner side. So they are supposed to represent first their pleadings.
So we will present
okay.
first, but
You may start.
second
You may
speaker.
start. You may start.
Sir, but second speaker is not yet in the show.
Just wait for just wait a minute, sir. Just wait a minute.
Please admit her.
पहले admit करो उनको. She is not at backstage, beta.
So she is there. Even she has texted in the group moot court competition that I'm still in the backstage A3.
Excuse me, sir. Even my co-counsel is in the backstage, and it's showing that the show is full. He is now in the meeting. Thank you, sir.
B5 speaker is here.
B5 speakers are there, both speakers are there. A3 speaker is not there. ठीक है. उनका को कनेक्ट नहीं हो रहा है. कैमरा कनेक्टेड नहीं है.
Sir, my co-counsel is with the name of A3. A3.
When your co-counsel is not connected with proper camera and mic, that's why he or she is backstage. Please reconnect with proper camera and mic.
Dr. Neeraj, you just complete with the setup. I'm just coming within 5 minutes. Give me 5 minutes. I'm just coming back.
Right. So team A3 and team B5. One of your team A3 is member not connecting. So you please tell her that she may join. Otherwise, we will proceed for another team within 5 minutes. And for next round, team A12 and B2 will enter. Okay, if it is not connecting, we will take you later on A3 and B5. Now I would request to A12 and B2. A12 is Punjab University Regional Center and B2 is GD Goenka University, Gurgaon. And their topic is constitutional law.
Good morning, sir.
Very good morning. You please introduce yourself.
Yes, sir. Sir, I'm St. Reeds from Punjab University Regional Center. So actually, there's some technical glitch that is coming. We are joining, but after 3-4 seconds, we have been leaving the meeting. Like there is some technical glitch coming in. We can't join.
You are from which team?
A12.
Is it A12?
A12. So where is your partner?
Only to the YouTube link.
Only A12 and B2. A12 is Punjab University and B2 is GD Goenka University, Gurgaon. They are supposed to enter. All are requested, other than these teams, to leave out the room.
Hello. Hello. Good morning, sir.
Yeah, very good morning. Please open your cam.
Sir, there's some issue that is coming with this link. My co-counsel is not able to join, and moreover, the link is being disconnected after 2 or 3 seconds again and again.
You are from team A12.
Yes, sir.
And another is anyone from B2.
Join okay.
Sir, A12 both teams are in. Both persons are in. A3, you are supposed to be backstage on YouTube link right now. The both teams are online. Sir.
Both teams are here. A12 Punjab University Chandigarh and B2. Switch on their mics. And now I would request to our judges, Dr. Vijender Singh ji, to please join us so that we may start the proceedings for today. You please switch on your cameras and mics also. A12 and B2. Our respected judge will join us very soon. It was due to technical problems. A12 is here as a petitioner and B2 is as a respondent. Is it clear to you all?
Yes, sir.
Yes, sir.
That's all are requested to join. Sir, please. Yes, sir.
Huh?
That's
Okay, you both teams are requested to start speaking. First, 8 will.
Good morning, sir. Can we start?
Yeah.
The councils have approached this honorable court on behalf of the petitioners in the matter of Civil Rights Society and others versus Union of India, Indus and others. The special leave petition filed in the matter of Civil Rights Society versus Union of Indus was clubbed by this honorable court along with the writ petitions in the matter of Mr. Robin versus Chairman Upper House Union of Indus and writ petition in the matter of Mr. Raman versus Speaker Lower House Union of Indus.
Just
The
a moment, council, you hold on, please. The fourth candidate who didn't open his camera. Okay, now you can start.
The council seeks permission from this honorable court to move on to the jurisdiction.
Permitted.
Grant, much obliged. The petitioner 1 has approached this honorable court with a special leave petition by invoking the jurisdiction under Article 136 of the Constitution of Indus. The petitioner 2 and 3 have approached this honorable court with a writ petition by invoking the jurisdiction under Article 32 of the Constitution of Indus. The council now seeks permission to move on to the statement of facts.
Please, forward.
Much obliged. The Constitution of Indus establishes the country to be a union of states, and its legal and policy framework are in parimetry to the Republic of India. The Parliament of Indus consists of the lower house, the upper house, and the President of Indus. From 2015 to 19, Mr. Robin held the position of Prime Minister in the country, but in 2020, a coalition government headed by Mr. Aryan was formed. The new government started investigating in the reimbursements that were claimed by Mr. Robin as the Prime Minister, the same which were approved by Mr. Aryan being the head of the Public Accounts Committee during the tenure of Mr. Robin. The matter was investigated by a subcommittee on whose report Mr. Robin was indicted for financial irregularity, and an FIR was registered against him by the chairman of the upper house. This very decision was challenged by Mr. Robin by way of writ petition under Article 32 of the Constitution. Mr. Raman, a member of the lower house and belonged to the same party as Mr. Robin, criticized the decision taken against him in his speech during the session of the House. At the end of his speech, two parliamentarians scribbled "Give me freedom," which was the title of the speech of Mr. Raman, on the walls of the House, which caused a ruckus. This very incident further led to scribblings in the walls of the capital city, as the entire incident that happened in the House was being live telecasted. An ethics committee was formed to investigate in this very matter, and based on the recommendation, the Speaker suspended Mr. Raman and the two parliamentarians. This very decision was challenged by way of writ petition before the Supreme Court, same being in violation of the fundamental rights and the constitutional norms. Further, A writ petition was filed by an NGO Civil Rights Society before the High Court of NCT, which challenged the constitutionality of Punjab Prevention of Defacement Act 1997, but the same came about to be dismissed. A SLP against the very same order was preferred before the Supreme Court, and the same was clubbed along with the writ petition filed by Mr. Robin and Mr. Raman, which is posted for hearing before this Honorable Court. If the Honorable Bench is well versed with the statement of facts, the Council seeks permission to move on to Issue 2, as Issue 1 and Issue 3 will be dealt by my co-counsel. Much obliged. Issue 2. Whether the action of the Speaker or the Chairman of the respective Houses against Mr. Raman and Mr. Robin, respectively, is violative of the constitutional rights, namely the legislative privileges, the freedom of speech, or not. The Council would like to explain this very issue in two folds. First, that the Speaker's actions are violative of the constitutional rights of Mr. Raman. It is humbly submitted before this Honorable Court that powers and privileges that are conferred upon the parliamentarians by the Constitution of Indus under Article 105 and the freedom of speech and the immunity that is provided thereunder, as mentioned in Article 105 Clause 1 and 2, are part of the privileges that are provided to the members of the Parliament. Mr. Raman was a member of the lower house and he used his privileges of freedom of speech without infringing any of his legislative rights, as the words that for which he is being penalized were said on the floor of the House while the session was in progress. Moreover, the action of the Speaker is in violative of the immunity that are provided to the parliamentarians. It is further submitted that the review petition that was filed by Mr. Raman came out to be disposed of by the Speaker itself, and it's contrary to the established rule of law that the same authority cannot sit as a judge to review its very own order. Thus, it is submitted that the action of the Speaker against Mr. Raman are arbitrary and violative of his constitutional rights. Mr. Raman has not breached any of these privileges that were conferred upon him by the Constitution. Second, the Chairman's action is violative of the legislative privileges of Mr. Robin. It is humbly submitted before the Honorable Court that Mr. Robin is being exorbitantly being investigated for expenses incurred by him during his tenure as a Prime Minister. The reimbursements that were claimed by him were in accordance with the benefits that are conferred upon the members of the Parliament, as per the Salary, Allowances and Pension of Members of the Parliament Act 1954 and the rules that are made thereunder. The expenses were consented to and approved by Mr. Aryan, who was the then chairman of the Public Account Committee and who is the present Prime Minister. And the same was also audited by the Comptroller and Auditor General of Indus, and no irregularities were found at that time. Mr. Robin, being the chairman of the Public Accounts Committee, when he was referred with his own matter, he further referred it to a subcommittee because he was well known with the maxim that is well established that the same authority that no one should sit as a judge in his own case. The entire charade was with the sole purpose to divert the attention from the drawbacks of the ruling government to tackle the new wave of pandemic. Thus, it is humbly submitted before the Honorable Court in the light of these preceding submissions that the action of the Speaker or the Chairman of respective houses has undoubtedly infringed the constitutional rights of both Mr. Raman as well as Mr. Robin.
The Counsel for Petitioner seeks permission from the Honorable Court to proceed to Issue 1.
Please.
Much obliged, Your Lordship. Whether the power of the legislature to punish for contempt, including the breach of its privilege, is essentially a judicial function or not. If yes, whether it is in tune with the modern constitutional principles to entrust such powers with respective legislature or not. It is humbly submitted before this Honorable Court that in the instant case, the Council has the locus standi to approach the Honorable Court under Article 32 of the Constitution of Indus, which is a fundamental right in itself. It could be proved in four folds. Firstly, the violation of the fundamental right of equality. It is humbly submitted before this Honorable Court that the action of Chairman and Speaker is violative of Article 14, that is equality before law. It is submitted before this court that the benefits offered to Mr. Robin, such as living and staying at ASIA, were the same as were given to the previous Prime Minister, and Mr. Robin's expenses were approved by Mr. Aryan, the present Prime Minister, who headed the Public Account Committee during the term of the office of Mr. Robin. The same were further audited by the Comptroller and the Auditor General of India. Secondly, the writ under mandamus. The writ of mandamus is a command issued by the court to public authorities to performance of the act which appertains to its office, and it is in nature of the public duty. In the Self Shamik Sangh versus Indian Oil Corporation Limited, it was held that the writ of mandamus would be issued if the refusal of the appropriate government is an irrelevant, irrational, or extraneous ground. It is issued to compel the performance of the public duties which may be administrative, ministerial, or statutory in nature. Here, the speech delivered by Mr. Raman is not amounting to the contempt of the House. Moreover, the review filed against the decision came to be disposed and retained by the same authority, which contradicts the well-established rule of law that the same authority cannot sit as the judge to review its own orders. Supreme Court under Article 32 has to pass appropriate orders to do the complete justice between the parties. Thirdly, the judicial review as the exclusive function of the courts. The interpretation of the Constitution is the exclusive function of the courts. The doctrine of separation of power doesn't stand in the way of judicial review in India, and Supreme Court have been placed as the custodian of the Constitution. In L. Chandrakumar versus Union of India, the power of the High Court of Judicial Review under Article 226 of the Constitution of Indus and the power of Supreme Court under Article 32 have been declared to be part of the basic structure of the Constitution, and same could not be excluded. Lastly, the arbitrary exercise of the power of the chairman and speaker. The legislative privileges are provided to the parliamentarians under Article 105 of the Constitution, which deals with the freedom of speech in the parliament, and that no member of the parliament shall be liable to any proceeding in any court in respect of anything said or any vote given in the parliament. Now, Mr. Raman, as being a respectable member of the parliament, has this freedom, and this freedom at this place is of absolute nature. Further, it is submitted that it is nowhere defined as to what amounts to breach of privilege and contempt, and the discretion of the House in this matter is mostly being misused by the House. Now, the Speaker initiated suspension and disqualification of Mr. Raman and the other two parliaments on the demand of various parliamentarians who are majorly belonging to the ruling political party. And the FIR against Mr. Robin for irregularity of finances is to drift the people's attention and to hide the government's failure, making it evident that the chairman has acted in the favor of the ruling party. Hence, in the light of the preceding submissions, the Council make this humble assertion that the legislature's power to punish for contempt, including the breach of its privilege, is essentially not a judicial function, and the same is not in tune with the modern constitutional principles. The Council for Petitioner seeks permission from the Honourable Bench to proceed to the issue 3.
Council, you people are, please do take care of time. You please
This is also I wanted to say, please keep yourself into the time being given to you, because it could be not appropriate. So kindly finish it off before the time, rather, I would say. Yeah, please proceed.
Much obliged, Your Lordship. Issue 3rd, whether the Punjab Prevention of Defacement of Property Act 1997 is constitutional or not, and whether the registration of FIR against unknown and the Member of Parliament under the Act is legal or not. It is humbly submitted before the Honourable Court that the Punjab Prevention of Defacement of Property Act is unconstitutional and FIR against unknown and the Member of Parliament are invalid. It could be proved in two folds. Firstly, the constitutionality. In state of Madhya Pradesh versus Rakesh Kohli, the test of constitutionality was held, which was the infringement of the fundamental rights and the jurisdiction of the enacting authorities. Article 30, which deals with that the state shall not make any law which takes away the fundamental right conferred by Part 3. And this was upheld in the state of Gujarat versus Ambika Mills also. And Article 19 talks about the freedom of speech and expression of the parliamentarians. And in Ramesh Thapar, the liberty to propagate ideas, that is, the publication is also included in term expression. In the Bennett Coleman versus Union of India, it was held that the test of pith and substance of subject matter in the object is irrelevant, and we only need to see the direct effect of the impute section on the fundamental rights. In the instant case, the state action infringes the fundamental right of freedom of speech and expression. The rational test against forbid government to impose the unreasonable restriction on the liberty and irrational restrictions also. Also, the subject of the act is material and not the form. In the present case, the Punjab Prevention of Defacement of Properties Act subject matter is beyond the jurisdiction of the enacting authority. Secondly, the FIR upon the unknown is infringement of the fundamental right, that is Article 19 Clause 1A, which is very important for the healthy democracy. Similarly, the FIR against Mr. Robin is a sheer misuse of power and is arbitrary, as the allowances and expenses of a member of the parliament are created by the joint resolution of both the houses, and they are overseen and controlled by the Public Account Committee. And Mr. Robin have been defamed, his virtuous character have been defamed, hence the respondents should be booked under section 499 and 500 of the Indus Penal Code, and also under section 211 of the Indus Penal Code, which deals with the false charges of offence with the intention to injure. For example, in the present case, the false charge of financial irregularity have been against Mr. Robin. Hence, in the light of the preceding submissions, the Council make this humble assertion that Punjab Prevention of Defacement of Property Act 1997 is unconstitutional, as it clearly violates the fundamental right under Article 19 Clause 1A and also the parliamentary privileges. In addition to this, the Council also asserts that the FIR registered against the unknown person and the Member of Parliament under this Act is illegal and also arbitrary in nature. If the Honourable Bench is contented with the submissions made by the Council, it would like to conclude the contentions with the prayer. Your Lordship, much obliged. In the light of the issues raised, arguments advanced, and authorities cited, the Council, on behalf of Petitioner, most humbly prays and implore before that this Honourable Court may be pleased to adjudge the power of the legislature to punish for contempt, including the breach of its privilege, to essentially not be a judicial function, considering the same to not to be in tune with modern principles. The action of Speaker and Chairman of respected houses against Mr. Raman and Mr. Robin as being violative of their constitutional rights, the Punjab Prevention of Defacement of Property Act 1997 to be unconstitutional in nature, and FIRs registered against unknown and the Member of Parliament under this Act as illegal, and or pass any order, direction, or relief that this Honourable Court may deem fit in best interest of justice, equity, and good conscience.
The Council, on the behalf of respondent, solicits the permission to begin, Your Lordships.
Yes, proceed, please.
Much obliged, Your Lordship. With the Constitution in my heart, I, along with my co-counsel, is present here on the behalf of respondent in the matter of Robin versus the Republic of Indus, Raman versus Republic of Indus, and also clubbed with a special leave petition, NGO Civil Rights Society versus Republic of Indus, as Your Lordships. Your Lordship, with your kind consent of Your Lordship, may I address the bench collectively, as Your Lordships? Much obliged, Your Lordships. Your Lordships, in the disputes today, we have raised total of 3 issues, out of which I'll be dealing first 2 issues, and I'll be taking total of 8 minutes of the court's time, furtherance to which my co-counsel will be dealing with the very last issue, and he'll be taking the 7 minutes of the court's time, as Your Lordships. So I hope the court master has noted the same. Would Your Lordship appreciate a brief perusal of case in hand, or we can directly move on to the submissions, as Your Lordships? Much obliged, Your Lordship. With the kind consent of Your Lordship, the council is directly moving on with the submissions, as Your Lordships. Much obliged, Your Lordship. May I please the court? Much obliged, Your Lordships. Your Lordships, in this particular context of the case which we have in hand now, is my very first submission pertains to the power of legislature to punish for contempt, including the breach of privilege, is essentially a judicial function or not. The council's submission in this regard is negative, as Your Lordship, because it's not a judicial function, it's a legislative function, as Your Lordship, in this particular context of the case in hand. So, Your Lordship, I would like to prove this contention on 2 bases, as Your Lordship, 2 key submissions. First, I would like to put on spotlight on the Article 118, and second, I'll be putting a spotlight on the Article 122 of the Constitution of Indus, as Your Lordships, 1950. So, Your Lordship, in this particular instant of the case in hand, according to Article 118 of the Constitution of Indus, Chairman and Speaker is primary in the conduct of the business of the Parliament, as Your Lordship. So, second, also, it must be co-read with Article 122, where it's so plain and unambiguous, as Your Lordship. This word, this Article 122 is so plain and unambiguous. I don't know, the council, on the behalf of respondent, don't know why the petitioner has molded it in their own forms, as Your Lordship, because it's clearly written, quote, not to inquire into the proceedings of the Parliament, as Your Lordship. Because, Your Lordship, there lies a separation of power, as Your Lordship, because legislature, judiciary, and the executive, as Your Lordship, they have their own arena of work, they have their own independent arena of work, because they have their own principles, their own guidelines for working in those particular boundaries and particular parameters, as Your Lordships. So, Your Lordship, the petitioners has prayed in their prayer that they have that it's not a judicial function. If the petitioners are saying it's not a judicial function, then why you have approached to the Supreme Court? It's a very basis question, as a Lordship, because if they are contending that it's not judicial function, then why they are wasting the court's time, and it's a total wastage of the precious time of the court. If they are making and conflicting arguments, they are also coming to the court and also saying it's non-judicial decision. So why you are coming to the court, as Your Lordship, in this particular instant of the case? And very second conflicting thing in this particular instant of the cases, your lordship, they have approached to the Supreme Court for the quashing of FIR. Hereby I would like to say that, is it appropriate authority to that he'll be that the Supreme Court will quash the FIR? No, your lordship. Under article 1A 120 226 of the Constitution of Indus 1950, it's clear that the High Court is the appropriate authority to quash an FIR. So why they are not following a particular procedure, and why it is being violated? So they are extremely violating the constitutional principles, and it's a progressive constitutional principle, as your lordship, which we are following as of now. As your lordship, I would like to also cite that as we follow the liberal democratic principle, and we are lordship, I would like to contend that every law, let it be your lordship, in this particular scenario, any law made by president or by prime minister or any member of the parliament, they have to follow the same laws that they are making it. It means that they are under the same umbrella. One can't go outside of the umbrella and say that I am outside of the law, and that they can disregard the constitutional principles, which B.R. Ambedkar, his committee, has taken 2 years, 11 months and 17 days to short with, and with over and over judicial review and constitutional debates, as your lordship. It must not be disobeyed in this particular context, as your lordship. And your lordship, in this case, let it be the principal, and let it be the vice chancellor or the university, as your lordship, of any particular university. They are making the laws. It does not mean that they are outside the laws, as your lordship. They are also that part of the law. See, they must follow the supreme law of land, the Constitution of Indus 1950, your lordship. And also in this context, I would like to say that the petitioner has n number of times cited rights. But in this particular case, as your lordship, they have said rights to immune from proceeding, right of parliamentary privileges, right to fair criticism. But they have just forgot their duties, as your lordship. Rights always comes with duties. And as in this context, I have newspaper in my hand where president has clearly said the day before yesterday, rights, duties, two sides of same coin. From duties, its flow rights, as your lordship. So these are the flip sides of the coin. Duties also come if you are intruding into the rights of another person, and you are violating your duty. So it must a mere breach of privilege and contempt, as your lordship, in this particular context. In case Vananda Bharti case, it is a 13-bench judge case. There is always an implied authority of the legislature, as lordship, and it's a narrow scope that legislature can't go beyond their own boundaries, as your lordship. But and next, I would also like to point out one very important thing. Any publication can be made if it is a part of public house proceeding. But in the lower house, why Mr. Raman has made the speech which is regarding the upper house, as your lordship? In this particular context, the thing was regarding the upper house, and he has mentioned all the speech was basis of the lower house. So one must not publish any speech, any judgment, anything which is beyond the scope of that particular house, as your lordship, because they have he has also done a misleading statement and made a misleading statement on that, because your lordship soon a disorderly behavior which is so derogatory, not only tainting the dignity of that particular MLA or MP, but also tainting the dignity as a whole, your lordship. If I am doing a particular act, I am also tainting my dignity, and I am also tainting my parents' dignity in this context, as your lordship. So here the parents and guardian in the legislature is the head speaker, because it was going live, and they have made a ruckus on the floor, as your lordship, and they have just not followed a proper procedure and conduct of the court in this particular instant of the case in hand. And very first day when I went to the Parliament Street of Indus, as your lordship, I had seen from my own eyes that they have made a ruckus on the floor, and there are n numbers of banners here and there with we want freedom, give me freedom. So what is this? This type of behavior? Is it not a disorderly behavior, as a lordship? They had created a chaos, panic like situation. And also the council seeks the permission to address that yesterday, your lordship, just yesterday in evening, the judgment has came. the judgment name is, it's regarding the 12 MP member of parliaments, 12 MP member of parliaments which were suspended for the 1 year. Yesterday evening the judgment has came at around 5:39 or 5. The judgment of Ashish Shelar and other versus the Maharashtra Legislative Assembly, which was recited by A.M. Khanwilkar as a lordship in yesterday's evening judgment, where it's clearly being said in the paragraph number 74 and paragraph number 34, that the article 118 is a general provision conferring the each house of the parliament to make its own procedure. The council seeks just a 1 minute extension for some wrapping up of the arguments. Much obliged, your lordships. Your lordship, in this particular,
Your counsel, you please wait. You please hold on, sir. It is
Yes, sir.
much beyond the time. So I would request to Dr. Brijender Singh ji, please take an initiative in this regard.
The council seeks the extension of only 30 seconds, your lordship. Only just 30 seconds for
Come on,
completing.
come on. Let's finish. Let's finish.
Yes. Much
Fast.
obliged, your lordship. So in this particular context of the case, there was just the ignorance of the laws, misuse of the chair, misuse of the authority as a lordship, and also the Article 51A is violated. And in conclusion, I would like to say that if the petitioner, they are the elected and reputed and the trusted authority of the state, trusted authority of the country, so it must be taking into cognizance that one deliberate misleading statement of that authority can create a chaos, panic in this particular context, in this democratic setup of the country. Because your lordship, also I would like to say that the key feature of democracy, that we can raise and make a free and fair criticism as a fair
Okay.
criticism, but that does not violate this.
Okay, Team B2. Yeah, thank you.
I would like to hand over the floor to my co-counsel who will be dealing with last issue. Much obliged, your lordship. May I please the court?
Neeraj ji, am I audible to you?
Sir, yeah, definitely.
इनका टाइम कीप कौन कर रहा है? Is it automatically getting signed off or what?
Sir, from now onwards, we will taking time of 25 minutes. It
Yes,
is
yes.
more than from now onwards.
Okay, so I guess इनका ये last issue का रह गया है, इसको करके I think so, because they have already taken 25, almost 50 minutes इनके हो चुके हैं sir.
50 minutes they have taken. So from
Please
next
finish it.
onwards,
Yes.
from next onwards, we will take care of time and we will let you know at 25 minutes.
Yes. So yes, last issue, please carry forward.
May I please the court?
Please start.
Thank you, Lordship. Lordship, today I have brought up with one issue in my own to deal before this honorable bench. My issue is that whether the Punjab Prevention of Defacement of Property Act 1997 is constitutional or not. And also I will also deal with whether the registration of FIR against unknown and members of parliament under the act is legal or not. My Lordship, is my most humble contention is that the Punjab Prevention of Defacement of Property Act 1997 is constitutional in nature. I don't know how the petitioner can claim any act as any provision can be unconstitutional. And also, my lord, FIR filed against unknown and members of parliament is legal under the act. My lordship, before starting my arguments, I would like to state Section 2 of Punjab Prevention of Defacement of Property Act 1997. In definition, it gives the clear definition of each and every term like defacement, property, and writing. For defacement, it includes impairing or interference with appearance of beauty, damaging, disfiguring, spoiling, or injuring. For the property, it states that property includes any land, building, hut, structure, wall, fence, so on. So, my lord, parliament will come under the category of property. And also definition of writing includes decoration, lettering, ornaments produced by the stencil. So my lordship, this spray paint done by Mr. Raman will also come under the category of writing. So if all the three classes are satisfied in the section 2 of Punjab Prevention of Defacement of Property Act 1997, then section 3 will come into the play. Section 3 states that whoever defaces any property in public view by either by writing or marking with ink, chalk, or paint, or any other material by erecting staff, they can be punishable with imprisonment of 6 months or with a fine or with both. So my lordship, it's very clearly seen in the fact that in para 14 of Moot proposition that Mr. Raman took out the paint spray and sprayed on the parliament wall. So my lordship, And also, the important thing to be noted is that the Punjab Prevention of Defacement Act 1997 state that whoever in section 3. This term, whoever, plays a very important and crucial role in section 3. Whoever means who is guilty of defacing the property. That act, the Punjab Prevention of Defacement Act, does not lay down separate category for member of parliament. It simply says whoever who is guilty of defacing the public property or any other instrumental. So there is no separate category for member of parliament. So all the parliamentary members are also coming under the umbrella of citizen of Indus. So they can be punished under section 3 of
You
Punjab
just slow
Prevention
down,
of.
Council. I hope, Dr. Saab, it is over.
It is over.
Sorry, ma'am.
मैं अभी स्टॉप क्लॉक में टाइम ही चेक कर रहा था. It is over now.
Right, sir. So I would like to
Thank
call
you.
upon the second team, A1
Yes.
and B7.
A1
You
and
may
B7.
leave now. You may leave now. Now I would like to call upon A1, Guru Gobind Singh IP University, and B7, SRM University, Sonipat. So I would also request to Ajay sir to please make them convenient to join the meeting. Make them convenient to join the meeting. टाइम नोट कर लेना मैम 12:20 जैसे स्टार्ट होता है. So I would request to please take initiative and start your.
The Council for Petitioners seeks permission to present before the branch for the sake of brevity.
Please, please.
Much obliged, Your Lordship.
Yeah. Thank
If
you.
it may please the Honorable Court, the Council will be dealing with issue number 1, that is whether the power of the legislature to punish for contempt, including the breach of its privilege, is essentially a judicial function or not. If yes, whether it is in tune with the modern constitutional principle to entrust such powers with respective legislatures or not. And the co-council will be dealing with issue number 2, that is whether the action of the Speaker or Chairman of the respective houses against Mr. Raman and Mr. Robin respectively are violative of constitutional rights. And thirdly, whether the Punjab Prevention of Defacement of Property Act is constitutional or not.
Council, sorry to intervene you in between. You have 25 minutes altogether, both the teams. So you also do
Yes, Your
take care
Lordship.
of the time of the another team. Okay.
Yes.
Certainly, Your Lordship.
Very true. Very
If
true.
Your Lordship is well versed with the facts, the Council seeks permission to proceed with the issues.
Please, please, please. Just do take care of the time only. Thank you.
Sure, sir.
Carry on.
It is humbly submitted that issue number 1 is with respect to the power of the legislature to punish for contempt, including the breach of its privilege, being a judicial function. It is most humbly submitted before the Honorable Court that the idea of contempt of the Parliament emerged in the English Parliament in order to gain autonomy from the Crown when the judges of the royal courts were at the pleasure of the monarch. Today, when the Republic of Indus has declared itself a sovereign democratic republic, this requirement ceases to exist. Further, Your Lordship, it is respectfully submitted that the emphasis on separation of power in today's age is defeated if the power to take legal action against someone is given to any other organ of the government apart from the judiciary. Your Lordship, Montesquieu, a renowned jurist, states that there is no liberty if the judicial power is not separated from the legislative and the executive. Whether it joined with the legislative, the life and liberty of the subject would be exposed to arbitrary control. For the judge, then would be the legislator. Since Indus is a very federal country defined as a union of states and believes in strong democratic values emphasized in our constitution, the idea of legislature should be to make a decision on contempt defeats these ideals. It is worth noting here that it is Parliament's practical inability to impose procedural safeguards and controls that protect people facing charges in a court of law, as well as the court's well-developed expertise in reviewing decisions of other tribunals to ensure compliance with the procedural fairness principles. It is submitted that Your Lordship, principles of natural justice require that one cannot be made judge in his own cause. However, the Speaker who belongs to the House whose contempt has been committed and often continues to have political interests cannot meet this standard. There is no constitutional convention in Indus akin to one in UK that demands that the position of the presiding officer be unbiased and neutral. As a result, in Indus, the presiding officer often retain their party affiliations even after being elected as the speaker. albeit with a few exceptions. In the light of this lacuna, there have been indeed various instances of biased behavior which show that the decisions in cases pertaining to the contempt of court can be violated by the speaker's political interest and thus violate the fundamental rights of the accused under Article 21. As per rules and procedures of conduct of business in Lok Sabha, contempt is defined as as a matter of fact, your utmost attention is invited to your lordship in yesterday's judgment in the case of Ashish Seller and others versus the Maharashtra Legislative Assembly. The court had further expounded and upheld the saying of the Privy Council in Barton versus Taylor that I quote, the principle on which the implied power is given confines it within the limits of what has been required by the assumed necessity. That necessity appears to the lordships to extend as far as the whole duration of the particular meeting or sitting of the assembly in the course of which the offence has been committed. It seems to be reasonably necessary that some substantial interval should be interposed between the suspensory resolution and the resumption of his place in the assembly by the offender, in order to give opportunity for the subsidence of heat and passion and for reflection on his own conduct by the person suspended. Nor would anything less be generally sufficient for the vindication of the authority and the dignity of the assembly. Based upon the same, the council would like to contend that the expulsion of the other two first-time parliamentarians was well beyond the ambit of the powers of the Speaker of the lower house. Therefore, it is humbly submitted that the power to define and punish for contempt must be strictly made a judicial function and not a legislative one. Having said that, now with your permission, your lordship, my co-counsel would be dealing with the second and the third issue.
The council now seeks permission from your lordship to
Yes,
proceed
yes.
with the
Yes,
issue. Much obliged,
please.
your lordship. It is humbly submitted that issue number 2 is with respect to the actions of Speaker and Chairman of the respective houses against Mr. Raman and Robin, respectively being violative of their constitutional rights, namely legislative privileges and freedom of speech. Your Lordship, it is respectfully contended in the first sub-issue that Mr. Raman's constitutional rights, being a member of Parliament, were violated. Article 105, Clause 2 of the Constitution of Indus protects members of the Parliament from proceedings in any court with respect to anything said by him in the Parliament. In the present case as well, my client, Mr. Raman, was suspended for 6 weeks on basis of the speech that he gave in the Parliament. This action of the Speaker was violative of the parliamentary privilege of my client granted under Article 105 of the Constitution of Indus. Your Lordship, it is most humbly submitted before the Honourable Court that the freedom of speech of members in the House, in fact, is the essential prerequisite for the efficient discharge of their parliamentary duties, in the absence of which they may not be able to speak out their mind and express their views in the House without any fear. In the case of MSM Sharma versus Sri Krishna Sinha, the court held that, and I quote, applying the doctrine of harmonious construction, Article 19, Clause 1, Subclause A is a general provision, while Article 105, Subclause 3 is a special provision, and thus the former must yield to the latter. Therefore, they deem that Article 19, Clause 1, Subclause A does not control Article 194, Subclause 3 or Article 105, Clause 3. And the powers, privileges, and immunities conferred by the latter do not yield to the fundamental right of the citizens to the freedom of speech and expression. Additionally, in the case of Tej Kiran Jain versus N. Sanjeeva Reddy, the Supreme Court held that Article 105, Clause 2 confers immunity inter alia with respect to anything said in the Parliament. The word anything is of the widest importance and is equivalent to everything. Going by the book Rajya Sabha at Work, written by the authorities of the Rajya Sabha Secretariat itself, contempt of the House may be defined generally as any act or omission which obstructs or impedes either House of the Parliament in the performance of its functions, or which obstructs or impedes any member or officer of such House in the discharge of her/his duty, or which has a tendency, directly or indirectly, to produce such results. Going by that definition, Mr. Raman in his speech doesn't appear to have committed any such contempt of the House. And even if we assume that such contempt was committed by my client, the Speaker, when suspending him, did not follow the proper procedure as inscribed in the Rules of Procedure and Conduct of Business in the Lok Sabha. According to Clause 2 of Rule 374, and I quote, it states that if a member is so named by the Speaker shall, on a notion being made, forthwith put the question that the member, naming such member, be suspended from the service of the House for a period not exceeding the remainder of the session. It specifically mentions that the Speaker needs to put forth a motion before suspending a member, which in our case has been refused to our client. Furthermore, it also states that the period of suspension should not exceed the remainder of the session, which in our case has by far been exceeded by Mr. Raman, who was suspended for 6 weeks. Your Lordship, it is important to note herein these rules were made by the House itself under Article 118 of the Constitution of Indus. Your Lordship, it is respectfully submitted that in the second sub-issue, that the basis of registering an FIR against Mr. Robin is violative of his constitutional rights and parliamentary privileges. It is pertinent to note here that all alliances are given to the MPs with reference to Article 106 as mentioned in the Moot Memorial, Para 13, page 13, by the decision of the Parliament itself. There is no external authority that allows the MPs to get more money for personal use. In 2019, Mr. Aryan happened to be the chairman of the Public Accounts Committee and approved all the expenses of the Parliament that year. It is therefore humbly contended that the FIR filed has been filed with malified intentions, being that Mr. Aryan himself, as the chairman of the PAC and his committee, approved the expenditure report of the lower house of the Parliament in the said year. Raising such issues without any basis were done under political interests, as Mr. Aryan's government was under fire due to the lackadaisical approach and non-preparedness to tackle the new wave of pandemics. Further, the expenditure and such financial issues of the Parliament has been audited by the Computer and the Auditor General of Indus, which was duly approved as per the rules of the business of the House. It is therefore submitted that all allowances given to Mr. Robin were compatible to the provisions of the Constitution of Indus, and therefore the FIR filed against him is violative of his rights under Article 106. The Council now seeks permission from your Lordship to continue with issue 3. Much obliged to your Lordship. It is most humbly submitted that issue number 3 is with the Punjab Prevention of Defacement of Property Act is unconstitutional. As per Article 19, Clause 2 of the Constitution of Indus, the right to freedom of expression can only be curtailed in the interest of the sovereignty and integrity of Indus, the security of the state, friendly relations with foreign states, public order, decency, or morality, or in relation of contempt of court, defamation, or incitement to an offense. Furthermore, it is suggested that if an irregularity is discovered in an act that violates the constitutional's fundamental principles, the presumption of act's validity be revoked. Since the Act of 1997 goes against the Part 3 of Constitution of Indus, it is submitted that it should be declared unconstitutional. The case of Chintaman Rao versus State of Madhya Pradesh has also been cited in support of the argument that where the language used in the statute is broad enough to cover restrictions on a fundamental right, both within and outside the scope of constitutionally permissible legislative action affecting the right, and the possibility of the law being used for purposes not sanctioned by the Constitution cannot be ruled out, the law must be declared wholly null and void. The Council now seeks permission to proceed with the prayer before the bench. Much obliged, Your Lordship. Wherefore, in light of the facts of the case, issues raised, arguments advanced, and authorities cited, this Honorable Court may be pleased to adjudicate that definition and punishment for contempt is a judicial and not a legislative function, adjudicate the actions of the chairman/speaker against the petitioners to be violative of the constitutional rights, adjudicate the Punjab Prevention of Defacement of Property Act 1997 as unconstitutional, adjudicate all charges under the FIRs under the Act as invalid and quash them, and pass any other order, direction, or relief that this Honorable Court may deem fit in the interests of justice, equity, and good conscience. And for this act of kindness, this humble petitioner, as in duty bound, shall forever pray. Thank you.
Warm greetings, Your Lordship. This is Counsel for Respondent. I'll be addressing issue number 1 and 2, and my co-counsel
Yes.
will be addressing issue number 3. Your
Carry on,
Lordship,
please.
if the court may please, the council seeks permission to address you as Your Lordship.
Permitted.
Much obliged, Your Lordship. Your Lordship, the counsel for respondent has approached the Supreme Court under Article 32 in response to the petition filed by petitioner. Your Lordship, issue number 1 is, as per issue number 1, it has been contended that there is separation of powers. But your lordship, is it a clear-cut separation of powers? After reading Article 122 Clause 2, I don't agree to that point because it specifies as no officer or member of parliament empowered to regulate procedure or the conduct of business or to maintain order in parliament can be subject to a court jurisdiction in respect of exercise by him of those powers. Your lordship, in Keshav Singh versus Speaker Legislative Assembly, it was held that no part that the privileges conferred on the members are subject to fundamental rights. The Supreme Court also held that any conflict arising between the privileges and the fundamental rights would be resolved by adopting harmonious construction. Your lordship, as per the rules of the parliament, a person found guilty of breach of privilege or contempt of house may be punished either by imprisonment or reprimand, or two other punishment may also be awarded to the members for that contempt, namely suspension or expulsion from the house. Your lordship, these punishments are prescribed by the rules of parliament, and for that any breach or contempt of house, the person or the member may be punished. If that breach is of grave nature, then the person may be punished by imprisonment. And if any pecuniary gain has been adopted from that particular contempt or breach, then imposition of fine could also be there. Prosecuting the offender, punishment given to its own member. If any contempt is committed by the members of the parliament, then he is to be punished by the house itself, which could also result in the suspension or expulsion of the member from the house. Your lordship, each house has a right to regulate its proceeding and in the way it deems fit and proper. Your lordship, it is humbly submitted that each house has its own jurisdiction over the house and no authority from the other house will interfere in the same. Under Article 118 of the Constitution, the house has been empowered to conduct its regulation for proceeding and cannot be challenged in the court, your lordship, on the ground that the house is not in accordance with the rules according to Article 118. Your lordship, it has been contended that that entrusting judicial powers in parliament is not in tune with modern constitution. But your lordship, it is in tune with the modern constitution because several countries have granted parliamentary privileges to its member. We can take the example of New Zealand Parliament, which accord its members parliamentary privilege like its British counterparts, preventing members from being sued or prosecuted for anything that was said on the floor while in session. But your lordship, another example is Parliament of Singapore, which accords parliamentary privileges to its members, and they also protect them from being sued or prosecuted for anything said on the floor while in parliament was in session or during any parliamentary committee meetings. Your lordship, in the 11th report of the Committee on Privileges of Lok Sabha, the committee, having considered the entire gamut aspects relating to parliamentary privileges, after analyzing all the case laws, ground realities, experts' opinion, they all come to a majority that codification of parliamentary privileges is not possible. The committee finally opinion that there does not arise any occasion for codification of parliamentary privileges and recommended against its codification. The codification of parliamentary privileges is basically resisted because it would make the privileges subject to fundamental rights, your lordship, and that will increase the judicial scrutiny, and evaluation of new privileges would not be possible after that. Your lordship, if the court may please, the council seeks permission to start with issue number 2. Much obliged, your lordship. Your lordship, issue number 2 specifies that the right to freedom of speech in the house is however circumscribed by the constitutional provisions and the rules. But still, when a member violates any of these rules, the chair has ample powers according to that rules only to deal with the situation. Your lordship, in the case of Raj Narayan Singh versus Atmaram Gobind Kher, the Supreme Court held that it would not be able to safeguard its authority and discharge the high functions entrusted to it properly if it had no power to punish offenders for that breach of that privilege. Your lordship, the Committee of Privileges emphasized that a member of parliament does not enjoy unrestricted license of speech. I repeat, your lordship, the committee has emphasized on that particular thing, that member of parliament does not enjoy unrestricted license of speech within the walls of the parliament also. The committee has observed it is against the rules of parliamentary debate and decorum to make defamatory statements or allegations of incriminatory nature against any person, and the position is all worse, your lordship, if the statements or the allegations are made against those persons who are not in a position to defend themselves. Because, your lordship, the person who is accusing is inside the premises of the parliament, and the person who is being accused is outside the premises of parliament, and the person who is accusing is guarded by the parliamentary privileges. So how would the person will defend himself? The privilege of freedom of speech can only be secured if members do not abuse it, your lordship. And in the instant case, Mr. Robin, Mr. Raman, and other two parliamentarians have conducted themselves in the manner which obstructed the proceedings of the House, your lordship, and all of which created a ruckus on the floor of the House. Hence, the speaker was right and totally justified in taking action against them. With this, your lordship, I would like to hand over to my co-counsel for issue number 3.
Your Lordship, if it may please the court, the council seeks the permission to argue on the third issue, that is whether the Punjab Prevention of Defacement of Property Act is constitutional or not.
Permitted.
Much obliged, Your Lordship. Your Lordship, the point to be noted is that my worthy opponents have said that it violates the freedom of speech and expression. Firstly, Your Lordship, this right is not an absolute right and subject to the restrictions contained under Article 19, Clause 2. Your Lordship, even every right comes with a duty, Your Lordship, and there is a fundamental duty being imposed under Article 51A, subclause I, that they have the duty to safeguard public property and to abjure violence. In the case of Mohan Kumar Singhania versus Union of India, the court has held that the statutes made according to Article 51, Clause A of our Constitution is totally valid, and thus from this, it can be seen that fundamental duties help in interpreting the constitutional provisions. Your Lordship, it is a duty to safeguard the public property, and in not doing so, they are just violating this particular duty. Your Lordship, in the case of court on its own motion was the state of Punjab, it was observed by the court that the increasing incidents of defacement of public property through pasting of posters, flags, remarks, etc. upon walls, buildings, fences, gates is a disturbing feature, Your Lordship. Your Lordship, if we look at the provisions of this particular act, Punjab Prevention of Defacement of Property, it punishes the individual only when it is done without the consent of the owner. There is a proper procedure being laid down, and the punishment is provided only if that procedure is not being followed, Your Lordship. Your Lordship, the committee which is headed by F.S. Nariman is in view that it's in the spirit of observation in MC Mehta versus Union of India that court needs to lay down principles on which liability could be fastened and damages assessed in cases in which, due to behavior of mobs and righteous groups, private property is vandalized and loss of life and property is occasioned to innocent persons, Your Lordship. Your Lordship, with these contentions, now I hand over the stage to my co-counsel to present the prayer.
With this, Your Lordship, if the court may please, the council seeks permission to start with the prayer.
Yes.
Much obliged, Your Lordship. Your Lordship, in the light of the arguments advanced, cases and authorities cited, the respondent humbly requests the Honorable Supreme Court of Indus to dismiss the writ petition, and in doing so, pass any other order that it may deem fit in the interest of justice, equity, and good conscience, all of which is respectfully and humbly submitted from the council on behalf of respondent. Much obliged, Your Lordship.
Your Lordship, the Council for Petitioners requests the Council for rebuttals.
Yes.
Your Lordship, it is being contended that the SLP filed by the Civil Rights Society was under the Article 136, whereas the respondents have mentioned that all the petitions are filed under 32 in their memorial. Secondly, Your Lordship, utmost attention is invited that the respondents have mentioned in para 14 of the memorial about Suresh Chandra Banerjee versus Puneet Goala case, in which it was held that members enjoy complete protection even though the words uttered by them in the house as malicious and false to the knowledge. Going by their own words and our case, our client Mr. Raman is not liable to any form of punishment at all. What the respondents contend. And thirdly, Your Lordship, just
Time
give me
over. Please,
30
please,
seconds,
please,
Your
please,
Lordship. I would
please
request
sign
30
off.
seconds more.
Sign off, sign off. No, sign off.
Okay, Your Lordship.
Next. Neeraj, this was team B7.
It's team A3, Chanakya National Law University, Patna, and B5, Trinity Institute of Professional Studies. You please start, and their topic is human rights.
Yes, sir.
So,
Sir, does the judge has the memorial present with him?
Sorry?
Does the judge has our memorial with him?
Yeah, must be. Please carry on.
Greetings. May the council address the bench as your lordship?
Yes,
Much obliged,
please.
Your Lordship. Your Lordship, the council in the case of Swiper versus the Republic of Umberpol and the state of Aura will be dealing with issues 1, 2, and 3 respectively, and the co-council would be dealing with the issues 3, 4th, and 5th. Your Lordship, the rest of 1 minute would be taken for the rebuttals, whereby the 12 minutes would be taken by both of us together. Your Lordship, this is to be said that this petitioner council has approached the honorable court under article 32 of this constitution as on behalf of petitioner. Is your lordship well versed with the facts of the case? Indeed, Your Lordship. Your Lordship is well versed with the facts of the case. The Council would like to proceed with the issues raised. Your Lordship, the issues raised, the first issue is whether the PIL filed before the Honorable Supreme Court under 32 is maintainable or not. Your Lordship, it is most humbly submitted that before the Supreme Court that the writ petition is maintainable because the petitioner has locus standi and sufficient interest. Your Lordship, the petition also involves the substantial questions of law. Thirdly, Your Lordship, this court is a sentinel on qui vive, which is the guardian to enforce the fundamental rights. Your Lordship, the petition is not barred also by the doctrine of laches. Your Lordship, this is to be said by the petitioner council that it is most humbly submitted that a public spirited person on behalf of a section of the society can complain against the violation of fundamental rights is maintainable. It has been given in the precedent of Sarban and Sonowal versus Union of India, citation number 3, paragraph 3 of the memorial on behalf of petitioner. Your Lordship, the council.
Council, you hold on, please. Sorry to interrupt you in the way. You have altogether 25 minutes. And it was started on 12:40. 2 minutes have been left. It is for your kind information, Council.
Entrepreneurship development.
All right. Indeed, so indeed, Your Lordship. Your Lordship, it is submitted that fundamental rights of the citizen should be guaranteed under Article 14, 21, and 29, which it has been infringed by the impunged legislation. Your Lordship, the petitioner is an unregistered association and does not have the bearing on its locus standi, and thus, in the case that has been mentioned in the citation number 7 of the Moot Memorial, the council pleads to refer to page number 3 of the Moot Memorial that the Supreme Court in the national interest allowed the petition of the unregistered association and thereby here to applying the doctrine of stare decisis, the petition is maintainable. Your Lordship, the substantial question of law here present in the present case is that petitioner represents an entire population of Aura. Your Lordship, even the issue that is due to the substantial question of law is increase in population of Aura. The indigenous tribe, the indigenous Aura people have reduced to a minority, and further, there is no violation of fundamental rights of the people of Aura in the specific and citizens of Umberpol in general. And thus, the Honorable Court in Sentinel on the qui vive. Your Lordship, it is to be assumed that the Honorable Court has repeatedly assumed the role of Sentinel on qui vive. The right to life guaranteed under under Article 21 also includes the right to environment and livelihood. Your Lordship, violation of fundamental right is a sine qua non of the exercise. Your Lordship, it is also not barred by the doctrine of laches. Your Lordship, the Council would like to refer to page number 3, paragraph number 12, that the Supreme Court has in various judgments has given no upper limit or lower limit. Your Lordship, therefore, the delay that has been arisen due to the continued false assurance by the government that is working towards the fulfillment of the tripartite agreement is there a valid reason for the delay, and thus the delay is not attributable to the petitioners. Your Lordship, therefore, the petition is maintainable. If your Lordship is satisfied with the issue 1, the Council would like to proceed with issue 2. Apologies, Your Lordship. Your Lordship, if Your Lordship is well with the issue 1, the Council would proceed with issue 2. Indeed, Your Lordship. Your Lordship, the second issue hereby is whether Section 6 of the Omberpal Citizenship Act as ultra vires the Constitution of Omberpal. Your Lordship, it is most humbly submitted before the Supreme Court that the Section 6A of the OC Act, that is the Omberpal Citizenship Act, is unconstitutional as firstly it violates the fundamental right. In addition, the influx of the illegal migrants into a country amounts to external aggression and internal disturbance, which is an amendment which is a violative of Article 355 of the Constitution. Your Lordship, even if the inapplicability of the principle of non-refoulement also makes the act ultra vires the Constitution, and as per the Article 13 clause 2 of the Constitution, the impunged act is void and liable to be struck down. Your Lordship, the Petitioner Council also submits that the Section 6A strikes at the arbitrariness of Article 14, which allows that there should be an ensured fairness and equality of treatment. Therefore, no action of the state should be an arbitrary and irrational one. Your Lordship, this is to also mention that according to Article 21, life is meant to have something more than a mere animal existence. But here in the statutory provisions runs that the impunged amendment grants citizenship to individuals from Mumbai who have illegally entered the aura. Therefore, Your Lordship, it is pertinent to note that the resources have turned scarce in aura, and the present population of aura is being demanding the resources, and therefore of which the persistent influx of the illegal migrants have been granted citizenship and thus have deprived the employment opportunities and livelihood opportunities in behalf of their native land. Your Lordship, even in the case of Sarbanand Sonowal versus Union of India, it has been held. Your Lordship, the precedent that has been taken in for the Article 21 is the Board of Trustee of Port of Bombay versus Dilip Nandrayani, where it has been written that equality of facet is an important content of right to life. Your Lordship, according to Article 29 clause 1, any section of the citizens residing in the territory of minority has to be given a certain distinct language, script or culture of its own. But here clearly the Honorable Court held the resident of a state object to illegal migration, as it has an adverse impact on the language script of the Aura people. Your Lordship, the impunged amendment is also violative of Article 355, as the respondent may argue that Article 355 cannot be invoked independently, but SS Jan versus Union of India has a precedent which says that the violation of constitutional rights of the citizen acts as violation, and thus it is humbly contended that the OC Act is unconstitutional. Your Lordship, even in the non-refoulement of inapplicability of the petitioner, fundamental right of a foreigner is given to the reserve to right to expel them, and right to reside has not been given. And the present case, it should be brought that there is no threat to the persecution of Mumbai. Thus, Omberpal need to be hesitant in deporting the illegal migrants. Therefore, it is submitted that the principle of non-refoulement is not applicable here. Your Lordship, the third issue which is held here is that whether the action of the Union of Omberpal in amending the Omberpal Citizenship Act on the basis of an agreement is valid. Your Lordship, it is most humbly submitted that the agreement violates the rule of conduct of government business under Article 77 of the Constitution, and it is also contrary to the constitutional provisions. Your Lordship, it is a violation of fundamental right. Therefore, the agreement and act should be declared invalid on the basis, and same must be quashed. Your Lordship, it is to be held that Article 77 states that all the executive action has to be taken in the name of President. But in the present case, it is to be hereby noted by the Moot problem that the Prime Minister of Omberpal has entered into the tripartite agreement with the government of Aura and it highlights that it has not been expressly mentioned that the president has come into the contract. So therefore, according to under Article 15 clause 3, 53 clause 1 of the Constitution, the executive power of the union was to be exercised by the president and not by the prime minister, and thus this agreement is invalid and must be quashed. Your lordship, it is also contrary to the constitutional provisions, as has already been mentioned by the council in Article 21, Article 29 clause 1 and Article 14. Your lordship, in the present case, thus the tripartite agreement is against the ideals of the constitution from the very day of the commencement. It tends to withhold the right of illegal migrants by deporting them. Therefore, it is submitted that the OC Act on basis of an agreement was invalid and must be quashed. Your lordship is, if your lordship is well versed with the third issue, the council would like to proceed with the fourth issue by the co-council.
इनका किसी का भी भेज को आइडिया हो जाएगा कैसे आई नो 8-10 लाइन होंगी मुश्किल से
So you have not audible.
लैब ना 3-3-6 ठीक
Please check the internet connectivity.
Ajay sir, you try to speak again. As far as issue 4 is concerned, you may start speaking again so that Dr. Saab can recognize.
Yes, please.
Team A3, Chanakya National Law University, Patna. You getting my voice?
Apologies, Your Lordship. The council would like to proceed with the fourth and fifth issue due to the paucity of time because the co-council is facing some technical issues.
You may proceed.
Yes, sir, I may proceed because she is facing
But
some
taking care of time.
Pardon, Your Lordship?
Taking care of your time.
Yes, Your Lordship.
With you.
Yes, Your Lordship. The 15 minutes that has been allotted to our team would be deducted by that because she's facing some technical issues.
I'm just waiting if everything is resolved now.
So the co-council is not able to.
Okay, I'm waiting. Yeah.
Your Lordship, if you allow, the council can also proceed with the fourth and fifth issue, or the co-council rejoin later, as you suggest.
So you are. She's present.
She's present, Your Lordship. But she's,
as an alternative. I think so. She's here, I guess. Yeah.
Yes, sir, but there is some network issue with her.
बेटे अपने ऑडिबिलिटी चेक करें आप प्लीज जल्दी. आपका अनम्यूट करिए अपने आप को.
So can we start with another member of the team who is?
Sir, if there is a paucity of time, I can also like present the fourth and the fifth issue.
कर सकते हैं क्या, Dr. Neeraj?
Maybe, sir. Maybe it's
please do the needful because time is lapsing. Yeah, please continue.
All right, sir. So the fourth issue here by Your Lordship is that whether the Section 3 of the Ombudsman Citizenship Act is valid or not. Your Lordship, it is most humbly submitted before the Honorable Supreme Court that Section 3 of the OC Act is constitutionally invalid because it is firstly the violation of Article 5, 14 and 355 of the Constitution and also incoherent with the other provisions of the OC Act. Your Lordship, thus it should be declared invalid. Your Lordship, Article 5 of the Constitution provides that the citizenship to person not only on the basis of citizenship of their parents but also on the basis of domicile of the person. Hence, not anyone who comes to the Ombudsman is given citizenship. Your Lordship, Section 3 of the AC Act promptly gives citizenship to every children of the illegal migrant. Your Lordship, therefore, Section 3 of the OC Act is violative of Article 5 and it goes against the core of the Article 5 of the Constitution. Your Lordship, even in paragraph number 40, page number 9, Your Lordship may refer that Section 3 is also violative of Article 355, as has already been mentioned by the Council, by external aggression and internal disturbance, because the Oro Youth United has created a huge ruckus and has provided with the protest, because of which there has been an internal disturbance and external aggression is due to the illegal migration. Your Lordship, therefore, giving citizenship to the children of illegal migrants amounts to promoting the external aggression and internal disturbance. Your Lordship, Section 3 is incoherent with the other provisions of the OC Act. Your Lordship, because the Section 3 is legally invalid as it contravenes with the OC Act itself, because Section 5A gives citizenship by registration and Section 6A also gives citizenship by naturalization, and Section 3 giving citizenship of one of the parents who are illegal reduces the above discussed section nearly ineffective. Your Lordship, it is also submitted that Section 8 also enables the person with dual nationality, which has been a case or a concept of jus sanguinis, and therefore in the operation of jus sanguinis, nationality has reference to jure relationship. Your Lordship, all citizens are nationals of a particular state, but all national may not be the citizen of the state. Your Lordship, Section 9 of the OC Act deals with another situation in which the renunciation of citizenship may take place, and Section 9 of the OC Act remains ambiguous on the point of acquiring citizenship. Therefore, there are dual allegiance to the Act has provided that the Section 3 of the OC Act will lead to the contravention of the OC Act itself. If Your Lordship is satisfied with the fourth issue, the Council would proceed with the fifth issue.
Yes, please.
Indeed, Your Lordship. Much obliged. Your Lordship, the fifth issue is whether provisions of the tripartite agreement are binding on the Union of Ombapal and the state of Ora, and they are liable to be provide compensation to the Oro people for committing a breach thereof. Your Lordship, it is most humbly submitted before the Honorable Supreme Court that the respondents are liable to compensate for the breach of violations of Article 14 and 21. Your Lordship, the tripartite agreement is valid and binding. Therefore, the government is liable for the compensation. Your Lordship, the violation of Article 14 and Article 21 has already been discussed by the Council, and the mandamus may be used to do justice when there is a wrongful exercise of power or a refusal to perform duties. Your Lordship, every state action must be informed by reason, and it follows that an act informed by the reason is per se arbitrary. And here, clearly, the act itself has been arbitrary, and giving it the tripartite agreement is binding. Apologies, Your Lordship. In the present case, the government, bound by the provisions of the agreement, has failed to provide the rights as enshrined in the agreement. Your Lordship, the Council would like to refer to page number 11, citation number 73, where it has been mentioned that there has been a curtailment to the right to life by the government, and therefore the breach of the agreement is violative of Article 21 of the Constitution. Your Lordship, the tripartite agreement is valid because the scheme has been framed under Article 73 of the Constitution, where a person claiming the benefit of the scheme would have the legal right to get it enforced. And here, in this, the present case, the unions of Ombalpur has framed the policy in continuation of the aforementioned, the individuals of the state of Ora. And Your Lordship, it was not later on provided on by the authorities, can be inferred from the reports published in the national magazine, Your Lordship. Your Lordship, the contract has been formed under Article 299 of the Constitution, and to form a government contract, the contract has to comply with all the essential requirements of the Article 299 of the Constitution itself. As has been mentioned in Bikhar Jaipuria versus Union of India, citation number 79 or paragraph number 52. Your Lordship, the government is liable for compensation because the case of Rudal Shah versus State of Bihar was the principal instance of its kind, where the Supreme Court conceded to pay under general society of the nation, that this was the achievement case. Your Lordship, compensation was in a way of palliative, keeping in mind the end goal to give a superior intending to one side of the life ensured under Article 21 of the Constitution. Your Lordship, the government is liable because the power of jurisdiction of Supreme Court and High Court to grant monetary compensation in the exercise of jurisdiction does not hold, is well established and thus are infringed. But Your Lordship, the court's power to grant damage cannot be limited only when the fundamental rights under Article 21 is violated. Therefore, the government is liable and should compensate for the committing the breach thereof. If Your Lordship is well versed with the fifth issues, the Council would plead prayer. Much obliged, Your Lordship. Your Lordship, wherefore, in the light of the issues raised, arguments advanced, authorities cited, this Honorable Court may be pleased to adjudge and declare that first, the writ petition is maintainable under Article 32 of the Constitution of Ombalpur. Strike down Section 6A of the OC Act. The amendment in the Ombalpur Citizenship Act on the basis of an agreement is not valid. Redefine Section 3 of the OC Act. Fifth, the provisions of the tripartite agreement on 1999 as binding on Republic of Ombalpur and State of Aura and make them liable to provide reasonable compensation to the Oro people for committing a breach therefore, and or pass any other order that it deems fit in the interest of justice, equity, and good conscience. And for this, the petitioner, as in duty bound, shall humbly pray.
Yeah, counsel, please allow the another team to speak something because you are
Yes, yes. Please,
court
please.
issues right now.
Yeah, allowed,
Please.
allowed.
Shall we proceed with our arguments, Your Lordship?
Yes, permitted.
Just a second, Your Lordship. Yeah, and Your Lordship, we hope that the glitches on the part of petitioner won't affect our stipulated time.
Of course. No, actually, yeah, it is a cumulative effort. It may, but let's you start. We will see. You just proceed with.
All right, much obliged, Your Lordship. Greetings of the day to the bench. May the council refer this bench as Your Lordship. Your Lordship, the council on behalf of the respondent humbly like to come up with the matter of Society for Welfare of Indigenous People of Aura versus Republic of Ombalpur. I shall be arguing for 7 minutes and my co-counsel will be arguing for 5 minutes. If the bench is well versed with the facts of the case and don't have preliminary inquiry, the council would like to proceed with the issues of the case. Issue 1, that the present petition filed by the Society for the Welfare of Indigenous People of Aura is not maintainable. It is humbly submitted that before filing a writ petition under Article 32, the availability of alternative and adequate remedies has to be taken into consideration. In the present case, the petitioner have directly approached the Supreme Court under Article 32 instead of exercising alternative and adequate remedies available under Article 226. It was held by the Honorable Court in Confederation of All Nagaland State Services Employees Association versus the State of Nagaland AIR 2006, decided by Supreme Court that the writ petition should be agitated at the first instance before the High Court of Judicature under Article 226. The decision delivered by a two-judge bench cannot be regarded as an unauthoritative
अभी
pronouncement.
ऐसा तो नहीं कि हम उसको दे दें और बाद में हमें कहीं और तो पढ़ाने के लिए नहीं भेजना ना किसी को, क्योंकि ये तो अभिषेक ने अपना इनिशिएटिव ले लिया, उसने तो हमें बता दिया. कोई और भी छुपा रुस्तम तो नहीं बेटा जो बाद में हमको अचानक से बताए. एक मेल तो आई थी यार विनय.
Further, it is submitted that this matter related to illegal immigration came into light in late 1998. Please refer to Para 7 of the Moot proposition for the fact check, Your Lordship.
एक देखो क्या करण बब्बर की कोई मेल आई.
Whereas the petition has been filed by an unregistered organization in April 2019, that is after a gap of nearly 21 years. It clearly shows a sleepover by the petitioners for violation of their rights. It is noteworthy here that in Tilokchan and Motichan and others versus HB Munshi and another, AIR 1968, wherein Justice SM Sikri himself stated that a delay of 12 years or 6 years would make a strange bedfellow with the direction or order or writ in the nature of mandamus, certiorari, and prohibition. The Honorable Court has several times reiterated that no relief should be given to the petitioners who, without any reasonable explanation, approached the court under Article 32 of the Constitution after an inordinate delay. Further, it is argued that the petition in the present case is filed on the basis of a report of a magazine in which several claims have been made to the tripartite agreement of 1999, although none of these claims are based on an authentic or genuine sources. It is pertinent to note that in Dr. B. Singh versus Union of India, which was decided on 11 March 2004 by the Supreme Court, held that it is too much to attribute authenticity to any information or fact merely because it has been published in a newspaper or journal or magazine or any other form of communication, as if it is the words of God. Hence, it shall need no reiteration that newspaper reports and magazines per se do not constitute any legally acceptable evidence. Moving further with issue 4, Your Lordship. that Section 3 of the Honorable Citizenship Act is constitutionally valid. In the instant case, there is no violation of fundamental rights contrary to the claims of petitioners, because the settlement of dispute with regard to foreigners is purely a policy matter, and such policy does not violate a statute or constitution. Your Lordship, in state of Arunachal Pradesh versus Khudiram Chakma, AIR 1994, the Supreme Court held that the decision regarding settlement of foreigners is a matter of policy. It is not unheard of in law that the court does not interfere in a matter of governmental policy, since it is the government to decide. Thus, the matter regard to the determination of immigrants from Mumbaians as citizens as an extension of settlement of immigrants is a matter of policy. Further, to consider a particular act against Article 14, there needs to exist unreasonableness in act of government. Section 3 of the Citizenship Act is a reasonable law because it gives a fair right, the right to have the citizenship to those children whose one parent is legal citizen of Umberpal. We cannot ignore the importance of one parent being legal citizen of Umberpal. Children living within the territory of this country are equally entitled to the right to know their identity. By differentiating them, the respondent cannot bound the children of illegal immigrants to pay the price for the wrongdoings of their parents. Also, this court in Rajesh Kumar case held the word personal liberty under Article 21 of the Constitution includes all the basic human rights of a man, and it is the duty of the state to protect the life, liberty, dignity of person within its territory without jeopardizing it. Further, in Shri P.G. Gupta versus the State of Gujarat, AIR 1995, it was held that the right to shelter is also a fundamental right given under Article 21, and this right guarantees the right to residence and settlement. Thus, it is pleaded that declaring Section 3 of Citizenship Act unconstitutional will take away the right to shelter of people who are living in this country for the past 2 decades. Moving further with issue 5, that the tripartite agreement of 1999 is not binding on the government of Umberpal and the state of Aura, and they are not liable to compensate Aura people for committing breach thereof. It is humbly submitted that the tripartite agreement in the present case doesn't fill essential conditions of Article 299 of Umberpal Constitution. According to Article 299, all the contracts or agreements made in the exercise of executive power of the union or of state shall be expressed to be made by the president or by the governor of the state. The Honorable Court held the contract invalid in Bhikraj Jaipuria versus Union of India, AIR 1962, wherein divisional superintendent entered into contract without mentioning on behalf of the Governor General. In the instant case also, the agreement was not expressed in the name of President and Governor General. Then the contract is not in the proper form and it is not enforceable. Article 299 is a mandatory provision. It is not discretionary provision. Your Lordship, it is submitted that while pleading for unconstitutionality of Section 6A, the petitioner themselves contended that the said agreement is invalid. Then how can they claim now that the agreement is valid and enforceable in the eyes of law for the purpose of compensation? With this, I end my say, and I would like to request my co-counsel to continue with issue 2 and 3.
May I please the court? Good
Yes,
morning.
yes. Good
The
morning.
council will be dealing with issue number 2 and issue number 3. May the council refer this bench as your lordship? Much obliged. It is humbly submitted to the court that the provision of Section 6A was included in the Citizenship Act in the year of 1999 by the amendment, which was the result of the agreement. With a due permission, your lordship, the council would like to deal with both issue number 2 and issue number 3 together, because if it is proved that the Section 6A doesn't ultra vires the constitution, then it will automatically prove that the amendment done in the Citizenship Act was valid. Your lordship, am I audible?
Yeah, counsel, you are audible. You are audible.
Much obliged, your lordship. For it is to be submitted that for section 6A, the petitioner said that the agreement is valid. The petitioner said that the agreement is invalid, and when it came to the compensation, they said that it is valid. Certainly, the court would have noticed it. The first question here arises that can an amendment be done on the basis of agreement? Yes, it can be done as it was the part of the policy of the government of that time. The second question here arises that making an amendment in respect of the agreement can make it invalid. The answer will be no, because the amendment done in the act was followed by the proper needed procedure, as it was of union list and was passed through the parliament. It is most humbly submitted that the Citizenship Amendment Act 1999, especially Section 6A, doesn't ultra-vires the Constitution and is not discriminatory, arbitrary, and violative of Article 21, 29, and is according to the basic structure of the Constitution. While dealing with Article 14, we cannot go through the plain reading of it because this may make several acts of the government void. It is not absolute in nature. It is to be submitted that all persons are not equal by nature, and therefore mechanical equality before the law may result in injustice. Thus, the guarantee against the denial of equal protection does not mean that identically the same rule of law should be made applicable to all the person, in spite there is a difference in circumstances or the condition. In the case of state of West Bengal versus Anwar Ali Sarkar, AIR 1952, the Supreme Court has laid down the two tests which is to be determined that the said law is constitutional or not. The two test was that the law should not be arbitrary, it should be based on intangible differentia, and the second test was that the differentia adopted should be rational, and there should be a reasonable nexus between the object sought to be achieved by the differentiation made. In this particular case, there have been made two tier of classification have been done by this amendment. First tier of the classification is that state of Aura was chosen from the rest of the state, and second classification was that a cutoff date was decided. Dealing with the first tier of the classification, by
I'm there. Yeah.
In the your lordship.
Yes, sir.
Is there any query, your lordship?
Team B5, your time is up. Already it's gone. It was lapse from my side also because I could not see the time because my laptop got off. But now I'm seeing that your time is already over. So could you please finish it within next 30 seconds?
Your lordship, I have just started my issue and I have two in my hands.
Okay, thank you.
Can you give me 2 to 3 minutes, your lordship? I will be much
Please
obliged
take less than that. Already your time is done.
Indeed, your lordship, I will try my best.
Finish in a minute. Finish in a minute. Thank you.
Yes. It is humbly submitted that in the matter concerning of the immigration policy and the citizenship in particular, it is the executive policy of the sovereign manifested by the competent legislation which would cover the decision making. It is submitted before the court that the legislative policy in regard are designed exclusively for the elected representatives. The power of exclusion of immigrants is therefore an incident of sovereignty belonging to a duly constituted nation state and immigration policy, which has an impact on the foreign policy of the state. So it should be let the parliament to decide what is best for them. In the omnipol federal structure, state have constitutional obligation to implement the CAA because as per Article 246 of the Constitution, the 17th entry under the Union list of the 7th schedule provides the exclusive power to Parliament to legislate on the matter relating to the citizenship, naturalization, and aliens. The plain reading of Article 11, it would be clear that the all provision from 5 to Article 10 shall not derogate the power of Parliament to make the provision with regard to the acquisition and termination of the citizenship and all the other matter relating to the citizenship.
Okay, Council. Thank you very much for your time. Your time is over now.
Please.
Left now. Next team. I would like to introduce A7 and B8.
Thanks.
Doctor, please write note down there. A7 and B8. A7 Government College Mumbai and Navrachna University Vadodara B8. You both the team are requested to take care of time. You have 12 minutes first and 12 minutes second one. So the first speaker do take care of time. Otherwise, you all four will have to suffer. You mind it?
Noted, sir.
You may start.
Okay, sir. So, I would like to start, sir. May it please this honorable court, I am Counsel Aman Agarwal and with me is Counsel Achal Pandey. We are counsels A7 appearing for the petitioner in the matter Society for the Welfare of Indigenous People of Aura versus the Republic of Umberpal and another. If the bench permits, may we address the bench as your lordship?
Please.
Much obliged, your lordship. If the lordship is well versed with the facts, we will begin the arguments, or does the lordship want us to give a synopsis of the facts? Am I audible, your lordship?
Please.
Would you like to give us would you like us to give you a synopsis of the facts, or would you like to us to move on to the arguments?
You just carry on with your proceedings.
Okay, sir. Your lordship.
Thank you.
Much obliged. So I would be presenting the arguments for the first three issues as mentioned in my memorial, and my co-counsel will be presenting the arguments for the other two issues. Your lordship, the petitioner has approached the Honorable Supreme Court of Umberpal under Article 32 of the Constitution seeking for the remedies for violation of the fundamental rights of the Oro people by the government of Umberpal. Inefficiency of the respondents to identify illegal immigrants and deport them has created problems for the Oro people to effectively enjoy their fundamental rights under Article 14, 21 and 29 of the Constitution. The lives and personal liberty of the Oro people have been affected adversely by the massive influx of illegal immigrants from Mumbai area, which is a clear violation of Article 21. Your Lordship, the petitioner has the locus standi to file this writ petition. If I may bring your Lordship's attention to paragraph G on page number 12 of the petitioner's memorial. Your Lordship, if you may come to page number 12 of the petitioner's memorial.
You may carry on. I'm just hearing. Don't worry. You just carry on. Yeah.
So as mentioned on in paragraph G on page number 12, in SP Gupta versus Union of India, Honorable Supreme Court dealt with the locus standi to file writ petition under Article 32 of the Constitution. And in paragraph 23 of the said judgment, Honorable Supreme Court held that, I'll just read the quoted paragraph. Any member of the public having sufficient interest can maintain an action for judicial redress for public injury arising from breach of public duty or from violation of some provision of the Constitution or the law, and seek the enforcement of such public duty and observance of such constitutional or legal provision. This is absolutely essential for maintaining the rule of law, furthering the cause of justice, and accelerating the peace of realization of the Constitution, of the constitutional objectives. Your Lordship, this gives us, the petitioner, the locus standi to file this writ petition. If I may bring your Lordship's attention to paragraph H on page number 13 of the petitioner's memorial, in Assam Sanmilita Mahasangha versus Union of India, Honorable Supreme Court dealt with the doctrine of lashes with respect to pleas under Article 21 and 29 of the Constitution. In paragraph 31 of the said judgment, Honorable Supreme Court has held that this kind of petition cannot be dismissed on the ground of delay or lashes. Accordingly, the petitioner submits that this writ petition is maintainable. With your Lordship's permission, I would like to move on to the issues and arguments.
Yes. Please carry on. I'm hearing.
Your Lordship, the issues under discussion in this matter are the constitutional validity of Section 3 and Section 6A of the Umberpal Citizenship Act, the power of the government of Umberpal to amend the Citizenship Act based on the tripartite agreement of 1999, and if the tripartite agreement is binding on the current government, and if so, are they liable to compensate the Oro people for the breach of such agreement? Does your Lordship want the council to repeat the issues, or may I go forward with the arguments?
No, please, you carry forward. Please.
Obliged, Your Lordship. Your Lordship, the petitioner submits that Clause A of the tripartite agreement is unconstitutional, as it violates Article 5, 6, 14, and 21 of the Constitution. Therefore, if the cause of action itself is unconstitutional, the action, that is amending the Citizenship Act based on the tripartite agreement, cannot be constitutional. Hence, amending the Citizenship Act based on the tripartite agreement by the government of Omberpur was unconstitutional, and it was arbitrary and ultra-vires to the Constitution, and the government of Omberpur was not within its powers to amend the Citizenship Act based on Clause A of the tripartite agreement when the clause in itself was unconstitutional. With your Lordship permission, I would like to move on to the next issue.
Yes, please.
Your Lordship, the petitioner submits that the impugned provisions of Section 6A of the Citizenship Act created a separate class of people living in Aura, giving special treatment to them vis-a-vis other similarly situated persons entering into and living in other states of Omberpur without any reasonable ground, in gross violation of Article 5, 6, and 14. With respect to other regions of Omberpur, the date of entry of these illegal immigrants, whether before or after 25th January 1991, does not change their legal status of citizenship, and they continue to be treated as illegal immigrants. Such a cutoff date has been arbitrarily inserted, forming the sole basis of Provision 6A of the Citizenship Act, and hence it should be stricken off. Your Lordship, the petitioner further submits that enforcement of Section 6A of the Citizenship Act has no doubt facilitated to a large extent the illegal migrants of Mumbai to continue to reside in Aura. This has resulted in rapid changes in the demographic patterns in Aura, and it is emerging as a serious threat to the very identity of the Aura people. According to a report published in February 2019 in the Ombers, which is a magazine, the population of Aura almost doubled since 1989. And Oro people have been reduced to a bare 38% of the total population. The presence of millions of illegal immigrants in Aura purportedly under the protection given to them by Section 6A of the Citizenship Act has adversely affected the language, script, and culture of the local indigenous people. Under the circumstances, it is submitted that the impugned provision is ultra-vires Article 29, subclause 1 of the Constitution, and therefore liable to be struck down. Your Lordship, my co-counsel would be continuing from here.
With your Lordship permission, I would move on to next issue.
Please.
Matter of time. So, Section 3 is unconstitutional insofar as it grants birthright citizenship to children born even if one of the parents is illegal immigrant. It is not only violative of Article 14, but it is also violative of Article 21, insofar as it treats a child of illegal immigrant on the same footing as that of a child of Umberpal citizen, and awards that child with the same and equal opportunities that which a Umberpal citizen would get. It is also in contradiction of Article 5, 6, 7, and 8 of the Constitution, as they encompass every possible scenario wherein a person would get citizenship. But nowhere had the founding fathers of the Constitution imagined a scenario wherein a child of an illegal immigrant would get citizenship. This has raised various questions as to the the state of Aura, where the people of Aura reside, have been reduced to minority in their own state itself. Thus, the petitioner humbly submits that Section 3 is unconstitutional and should be struck down. With your Lordship permission, I would like to move on to my next contention. Much obliged.
Yes, please.
Yeah. The fourth contention on which I would be arguing is that the tripartite agreement is binding on the government and they are liable under the tripartite agreement. The petitioner humbly submits that Article 299 of the Constitution empowers the President to enter into contractual agreement on behalf of the state. The petitioner further submits that in Samsher Singh versus State of Punjab, the Honorable Court had held that, and I would like to quote, the President as well as the Governor exercises powers and functions conferred on him by or under the Constitution on the aid and advice of Council of Ministers. Wherever the Constitution requires the satisfaction of President or the Governor for the exercise of the President or the Governor, the satisfaction required is not that of the personal satisfaction of the President, but of the sense of the cabinet system of the government, that is, satisfaction of Council of Ministers, on whose aid and advice the President acts and enters into contracts. Thus, it is doubtful whether such an interpretation as to the personal satisfaction of the President is correct, and we are of the view, for all practical purposes, the Minister or Council of Minister, as the case may be, the satisfaction of decision is constitutionally secure when his minister arrive at such opinion. Thus, in the present scenario, Prime Minister of Umbapal entered into tripartite agreement with the government of Aura and Aura Youth United. He was representing the president, and hence it was a valid agreement. And accordingly, considering the principle of collective responsibility being applied, the government of Umbapal is liable under the tripartite agreement and it is binding. The petitioner would further like to submit that, in the view of the arguments raised thus far, government of Umbapal is in breach of
Sorry,
tripartite
Council.
agreement.
Sorry, Council, to interrupt you. Judge Sir, for your kind attention. First team have 2 minutes left. Now carry on.
Much obliged. So, the government of Umbapal has not executed a single act towards detention, deportation of illegal immigrants in Aura, nor have they found quasi-judicial authorities for determination of citizenship status, nor have they taken any measures to protect Oro people and preserve their culture, and to provide reservations to Oro people as they had promised in the agreement. Further, the petitioner would also like to submit that in Nirabati Behra versus State of Orissa, the Honorable Court held that it follows that a claim in public law for compensation for contravention of human rights and fundamental freedom, the protection of which is guaranteed in the Constitution and is the heart of the Constitution, is an acknowledged remedy for enforcement and protection of such right. And such a claim based on strict liability made by resorting to a constitutional remedy provided for enforcement of a fundamental right. Herein, it is also important to note that the defense of sovereign immunity being inapplicable and alien to the concept of guarantee of fundamental rights, there can be no question of such a defense being available in the constitutional remedy. It is this principle which justifies the award of monetary compensation for contravention of fundamental rights guaranteed by the Constitution, and that is the only practical mode of redress available in the current scenario. Now, with your Lordship's permission, my co-counsel will proceed with the prayer.
Please carry on. Yes, permitted. Please.
Co-counsel, please unmute yourself.
I'm sorry, Your Lordship. Your Lordship, I would like to conclude the arguments for the petitioner now. The present writ is an attempt by the petitioner to seek remedy for the brutal violation of the fundamental rights of the Oro people under Articles 14, 21, and 29. In view of the arguments presented, the petitioner humbly prays this honorable court to issue writs of mandamus or any other appropriate writs declaring Section 3 and Section 6A of the Umbapal Citizenship Act unconstitutional and subsequently strike down the impugned provisions as ultra-vires to the Constitution. The petitioner further prays this honorable court to issue writs of mandamus or any other appropriate writs directing the respondents to treat the year in which the Constitution was enacted as the base year for the purpose of detection and deportation of illegal immigrants in Aura, to immediately take effective steps towards ensuring the deportation of illegal immigrants from the territory of Umbapal and declare that the respondents are liable for committing a breach of tripartite agreement and directing the respondents to provide compensation to the Oro people for the same. Lastly, the petitioner prays this honorable court to pass such further or other writs, orders, or directions as your lordships may deem fit and proper in the facts and circumstances of the instant case, and for this act of kindness, the petitioner, as in duty bound, shall ever pray.
If your lordship may permit, may the counsel for respondent begin directly with the issues. Lordship?
Yes, please. Yeah.
So the first two issues will be dealt by myself, and the other three issues will be dealt by my co-counsel. Moving further with the issues, the first contention that the respondent have is that there has been no violation of the fundamental right. Although the ambit of power conferred in the Supreme Court is wide under Article 32, the petition filed by sweeper is not maintainable, as there has been no violation of fundamental right. It is most respectfully submitted that a PIL writ petition can only be filed in the Supreme Court under Article 32 if a question concerning the enforcement of a fundamental right is involved. In Balco Employees Union versus Union of India, the court held that the only ground on which a person can maintain a PIL is where there has been an element of violation of Article 21 on human rights, Drawing inference from this case, it can be said that the present petition is not maintainable as there has been no violation of fundamental right. It has been held that if a person who comes to court with a PIL with vested interest, improper motion, or actuated by desire to win notoriety or cheap popularity are not entitled to file PIL. It is humbly submitted that delay also affects the locus standi of the petition in filing the PIL. There are 4.5 crore pending cases and 3.9 of which are in the Supreme Court. Thus, such delay affects the locus standi of the petitioner. The court may refuse to take cognizance of a public interest litigation if there is undue delay on part of the petitioner to file the same. It is further submitted that in the case of Rabindranath Bose versus Union of India, it was observed that no relief can be given to petitioners who, without any reasonable explanation, approach the Supreme Court under Article 32 of the Constitution after inordinate delay. The highest court of the land has been given original jurisdiction to entertain petitions under Article 32 of the Constitution. It could not have been the intention that the Supreme Court would go into stale demands after lapse of years. Though Article 32 in itself is a guaranteed right, it does not follow from this that it was the intention of the Constitution makers that the Supreme Court should discard all principles and grant relief in petition filed after inordinate delay. It is humbly submitted that Section 60 of the Citizenship Act was amended on May 23rd, 1999, and the PIL has been filed in April 2019. It is most essential to note that there has been an undue delay of 20 years in filing the PIL, and therefore the same is not maintainable. In order to preserve the purity and sanctity of the PIL, the Supreme Court in the year 2010 issued a following direction to be followed before entertaining a PIL. The court must encourage genuine and bona fide PIL and effectively discourage and curb the PIL filed for extraneous consideration. The court should prima facie verify the credentials of the petitioner before entering a PIL, and the court should be a prima facie satisfied regarding the correctness of the contents of the petition before entertaining a PIL. The court should be fully satisfied that substantial interest is involved before entertaining the public interest litigation. And therefore, it is humbly submitted that in a public interest litigation, the petitioner should not be inspired by malice or a design to malign others or be actuated by selfish or personal motives or by political or oblique consideration. It is further submitted that in the present case, SWIPA is an unregistered association and the PIL file does not have a bona fide intention or substantial interest. In conclusion, it is submitted that as violation of fundamental rights, it's sine qua non of public interest litigation, and this petition is not maintainable as there has been no violation of fundamental rights. Furthermore, the PIL is based on a magazine report which is not credible. The writ petition filed has been filed based solely on a report in a magazine called Ombers, wherein numerous claims have been made with respect to the tripartite agreement of 1999. It is pertinent to note that none of these claims have bona fide sources. The question of credibility of such source was questioned in the case of Dr. B. Singh versus Union of India, wherein the Supreme Court observed that the petitioners had referred and relied only on the representation of and the information of some paper cutting of news items. The Supreme Court, denying the credibility, held in their judgment that it shall be too much to attribute authenticity or credibility to any information or fact merely because it found publication in a newspaper or journal or magazine or any other form of communication, as though it is gospel truth. Hence, it shall need no reiteration that newspaper reports per se do not constitute legally acceptable evidence. The NCRB report of 2019 says there has been 214% rise in case related to fake news, and therefore the respondent requests to your lordship that such petition should not be encouraged. It is further submitted that the Supreme Court has ascertained that news reports are at best second-hand evidence, where report collect information and pass it on to editors, who edits the news item and then publish it. In this process, truth may get perverted or garbled. Such news items cannot be said to prove themselves, although they may be taken into account with other evidence, if other evidence are forcible. Moving on to the second issue in hand is whether Section 6A of Ombapal Citizenship Act is ultra vires of the Constitution of Ombapal. Article 14 of the Constitution of India reads that the state shall not deny to any person equality before the law or equal protection of law within the territory of India. It has been held by the Apex Court that equal treatment of unequal is not liable to be struck down as discriminatory unless there is a simultaneous absence of rational relation to the object intended to be achieved by law. It
Counsel,
is
sorry to interrupt you. You have 5 to 6 minutes left.
Yes, Your Lordship.
Move on.
Therefore,
Move on fast. Fast.
yes.
Yeah.
Therefore, it is humbly submitted in this instant case that Section 6A was added to put to rest the protest in Oro, and the baseline, that is 25th January of 1991, was introduced with the intention of detecting and deporting the persons of Mumbai and Urgent who entered into Oro after the said date. It is most respectfully submitted that the principle does not take away from the state the power of classifying persons of legitimate purposes, and this has been ratified in the case of Amironisia Begum versus Mehboob Begum. Article 14 denies equal protection only when there is no reasonable basis for differentiation. If a law deals equally with the members of a well-defined class, it's not obnoxious and is not open to charge of denial of equal protection on the ground that it has no application. The interpretation of Article 14 is based on the theory of classification that there is no absolute equality among human beings. And in this instant case, legislation by amendment and inclusion of 6A creates permissible classification as discussed in the case of Budan Chaudhary versus State of Bihar. Although case legislation is prohibited under Article 14, it does not forbid reasonable classification. Section 6A passes the dual test under Article 14 as it is based on intelligible differentia, and the differentia has rational relation to the object sought to be achieved. Now, further arguments will be done by my co-counsel.
If your lordship permit, may I advance to the next issue? Much obliged. The third issue in hand is whether the action of the Republic of Umarpal in amending the Umarpal Citizenship Act on the basis of agreement is challengeable. So it mainly focuses on the validity of the amendment. Article 11 of the Constitution enables Parliament to legislate on the acquisition and termination of citizenship after the commencement of the Constitution, and it also enables Parliament to legislate on the continuancy of citizenship at the commencement of the Constitution, even to extent of overriding or modifying the provision of arts. The Union of Umarpals has the right to amend the Umarpal Citizenship Act. It is humbly submitted that the Union of Umberland has exclusive jurisdiction over areas such as external affairs, defense, etc., and also has the primacy over states in certain matters enumerated in the Constitution of Umarpal. It is pertinent to note that in Article 246 of the Constitution of the Union has the exclusive jurisdiction to enact acts and laws according to this in regards to the citizenship. With reference to the aforementioned arguments, it is most humbly submitted that the respective amendment made to the Citizenship Act was within the power and scope of the Union of Umarpal. Later on, in relation to the amendment was in accordance with the international law. Under Article 15, the UDHR states none shall be arbitrarily deprived of his nationality nor denied the right to change his nationality. The Umarpal laws nowhere define the term refuge, which creates a legal vacuum with respect to the term refuge. It is most respectfully submitted that the preamble of the United Nations Charter starts from the people of the United Nations, implies that the relation among the states, which includes the concept of boundaryless and the global as a single family. It is humbly submitted that Umarpal judiciary, though not empowered to make legislations, is free to interpret Umarpal obligations under international law into the municipal law of the country in pronouncing its decision in a case concerning issue of international law. Article 51C of the Constitution provides that the state should endeavor to foster respect for international law and treaty obligations in the dealings of organized people with one another. The directive principle, according to the Article 37, are not enforceable through the court of law. Nevertheless, they are fundamental in the governance of the country, and there is an obligatory duty on the part of the state to apply this principle in making laws. In the case of Vishaka versus State of Rajasthan, the court observed that in the absence of domestic law occupying the field of any international convention, not inconsistent with the fundamental rights and in harmony with its spirit, must be read into those provisions to enlarge those provisions to to enlarge the meaning and content thereof, to promote the object of the constitutional guarantee. The traditional notion of
अरे
sovereignty
चारों
provides
दिखाइए भाई को तो दिखा नहीं बना रहा
provides a framework for countries to govern themselves. For issues like human rights or the environment, the human rights framework continues to provide the best possible avenue for ensuring that sovereignty is about states acting responsibly. Moving on to the fourth issue on hand, which is whether constitutionality of Section 3 of the Umarpur Citizenship Act can be challenged insofar as it grants birthright citizenship to children where even one of the parents is an illegal immigrant. Uh, the section the Section 3 of Umar Pul's Citizenship Act is valid. It is most respectfully submitted. The Section 3 of the Umar Pul's Citizenship Act plays a major role in fighting the increasing phenomenon of stateless child, and revoking it would be a uh, grave violation of human rights. Part 3 of the
Council,
Constitution.
your time is supposed to finish. I request to our Honorable Dr. Brijender Singh ji, please do take care of this thing. Their time has gone.
If your lordship permits an extent of 2 minutes, so that I can finish the issue in hand and prayer.
Okay, you may.
Much obliged. Uh, the part 3 of the Constitution cannot be fully
और उसके
understood
बाद
without
1 मिनट
taking. Okay, much obliged. Without taking into consideration the preamble as well as the part 4 dealing with directive principle of state policy. The Indian judiciary has not confined itself only to part 3 of on fundamental rights, but has also relied heavily on the DPSP. The 1898 Convention of the Rights of Children restates the universal protection and provisions on matter of citizenship and elaborates on the rights of children. Under Article 7, Article 7, the CRC declares that every child has a right to acquire a name and nationality, and stipulates the state should register births to make this happen. Moving on to the next issue on hand, which is the last issue, whether the other provisions of the tripartite agreement of 1999 are binding on the Republic of Omarpal and the state of Aura. Uh, the the tripartite agreement is not binding, as the tripartite agreement does not fulfill all the requirements of mentioned under the Indian Contract Act 1872, and also the condition given in the section 299 subclause 1 for the government contracts. It may be noted that, like other contracts, a government contract is also governed by the Indian Contract Act. A government contract has to comply with the provisions of Article 299, as Article 299 states that all contracts made in the exercise of executive power of the union or state shall be expressed to be made by the president or by the governor of the state. But in this case, the tripartite agreement was entered by the prime minister of the country, which does not fulfill the requirements mentioned under the Article 299 of the Indian Contract Act, which makes this tripartite agreement void. The three the three essentials of the mentioned under Article 299 are: they must be expressed to be made by the president, second, or to by the governor of the state, as the case may be, and the third, they must be executed by such execution must on behalf of the president or the governor by such persons, and in the manner they as may direct. As clearly from the arguments made above, it is clear that the agreement is void. If your lordship permits, may the council move on to the prayer. The prayer for relief, wherefore, in the lights of facts stated, arguments advanced, and authorities cited, it is most humbly submitted before the Honorable Court that it may be graciously pleased to adjudge and declare that the writ petition is not maintainable under Article 32 of the Constitution of Umarpal, the Section 6A of Umarpal Citizenship Amendment Act 1999 is not ultra virus. The Constitution of the Union of Umarpal, Section 3 of the Umarpal Citizenship Act 1955 is not ultra virus. The Constitution of Umarpal. The government of Umarpal is not bound by the tripartite agreement, and hence it is not entitled to pay compensation and pass any other order, direction, or relief that it may deem fit in the interest of justice, fairness, equity, and good conscience. For this act of kindness, the respondent shall duty bound forever. Pray.
With your lordship's permission, we would
Yes.
like 2 minutes for rebuttal.
Permitted, please.
Co-counsel, you may go ahead.
Thank you, Your Lordship. I would just like to mention one small thing. It was very insulting and wrong on the part of the respondents to submit that the petitioner is filing the present writ petition for cheap publicity. Now, continuing, we have already submitted the judgment holding doctrine of delay of lashes would not be a base to dismiss such petition. Now, the next thing, as the respondent said that submitted that as the petitioner is an association, he does not have the locus to file the petition. In Vishakha versus state of Rajasthan, Vishakha was an association, and the same petition was admitted, and it is now considered as a landmark judgment. So, on the similar lines, we have the locus standi to file such petition. Now, continuing to the evidence part about the Ombers magazine, we never presented it as an evidence. We just mentioned it as a demographic statistic. And your lordship may note that the respondent did not disagree with what the statistics was. So it is clear that they are accepting those statistics. So the admissibility of the evidence does not come into question altogether. Lastly, your lordship, in Samsher Singh versus State of Punjab, I would just like to quote the judgment again, which my co-counsel already quoted. The Supreme Court, Honorable Supreme Court held that Council of Ministers, when taking a decision, will be representing the President himself. Hence, when the Prime Minister entered into a tripartite agreement, he was representing the President. And he was not barred by Article 77 to not enter into the agreement. Thank you, Lordship.
Further, I would like, with your lordship's permission, I would like to
Sorry,
say
Council, your time is over.
Yes. I was about to say,
You may
please.
left now. You
May
may
the
left now.
respondent
Thank you very much.
respond to the contentions?
Please.
You may left now.
Yeah.
Much obliged, your lordship. Thank you, lordship.
Thank you. So nice of you. And I am inviting the next team and the last team, A11 Kerala Law Academy, Trivandrum, and B9 Indore Institute of Law, Indore. Doctor, please note down, and it would be the last round. And you please
Right,
give
sir.
me results so that I can announce the semi-final round at 2:30.
Perfect.
Right, sir.
And I would like to talk over phone the moment this round will be over.
Yeah,
Sir.
I will talk to our phone, sir.
Sure, sir. Please carry on with the last team.
Council, you have 25 minutes with you. First team will take 12 and a half minutes, and another is 12 and a half minutes. You please do take care and on your cameras, please. You start now. You may start.
Greetings. Your Lordship, is the council audible? Your Lordship, is the council audible?
Audible. Please carry on.
Much obliged, Your Lordship. Greetings. May the council address the bench as Your Lordship?
Yes. Permitted.
Much obliged, Your Lordship. May it please this Honorable Court, this is Counsel A11-1, appearing along with my co-counsel A11-2 as the counsels for the petitioners in the case concerning Civil Rights Society and others versus Union of Indus before this Honorable Supreme Court. If Your Lordships are well versed with the facts of the case, may the counsel move on to her contentions? Much obliged, Your Lordship.
Yeah.
Much obliged, Your Lordship. The first two contentions will be dealt by this council, and the latter merits of the case will be dealt in detail by my co-counsel, Your Lordship. The council's first contention is that the Supreme Court has the jurisdiction to try the present case under Article 136, Your Lordship. Your Lordship, under Article 136 of the Constitution of Indus, it clearly states that the judgment that the Supreme Court may grant specially a petition to appeal from any judgment, decree, order, sentence, or determination in any case or matter passed or made by the court or tribunal in the territory of Indus, Your Lordship. In case Haripada Dev versus State of West Bengal, reported in All India Reporter 1956, Supreme Court, page number 757, the Supreme Court held that it will grant specially petition only if there has been gross miscarriage of justice or departure from legal procedure which violates the whole trial or findings or facts shocking to the judicial convenience of the court, Your Lordship. Your Lordship, when there is a miscarriage of justice by the lower court, in such circumstances, the High Court will intervene. Your Lordship, in this present case, since there was a repugnant order by the High Court of the NCT of Indus, the petitioner has approached the Supreme Court under Article 136, Your Lordship. Therefore, it is humbly submitted by the Council that this present case is maintainable and the Supreme Court has the jurisdiction to try the present case under Article 136, Your Lordship. With Your Lordship's kind permission, may the Council move on to her second contention.
You may please.
Indeed, Your Lordship. The counsel for the petitioner's second contention is that the power of legislature to punish for its contempt, including the breach of its privilege, is not essentially a judicial function that has to be vested upon the legislature and is against the democratic principles, Your Lordship. Your Lordship, under Article 105, which states about powers, privileges and immunities of the House of the Parliament and the members of the Parliament, and from Article 105 subclause 3, we can clearly understand about the inheritance from the UK Parliament. But Your Lordship, unlike England, where the Parliament is sovereign, Indus is a federal and democratic state with a written constitution, Your Lordship. Your Lordship, in the case Raja Rampal versus Honorable Speaker, reported in All India Reporter 2007, Supreme Court Supplementary, page number 1448. From this case, it states that the legislative supremacy being subject to the Constitution, Parliament cannot determine for itself scope, the nature and effects of its power, Your Lordship. Your Lordship, it is humbly submitted that unlike England, where unlike England, legislature of Indus has never been that of a court of record, and the privileges must have certain limitations, Your Lordship. Also, Your Lordship, the petitioner would like to point out that as the Parliament of Indus is not a court of record, then the powers for Parliament to contempt for the privilege under Article 105 does not give the legislature a general power, Your Lordship. This power can be used to safeguard the authority and enforce discipline in the House, but cannot be used to misuse the power to suppress the democratic voices in Indus, Your Lordship. Since the privileges are not codified, this power can be misused and they are kept higher than the fundamental rights, that is right to freedom of speech and expression, Your Lordship. In the case Gunpati Keshavaram Reddy versus Rafisul Hassan and State of UP, reported in All India Reporter 1954, Supreme Court, page number 636, it was ruled out that privileges under Article 105 cannot be higher than any fundamental rights, Your Lordship. Also, Your Lordship, in the case MSM Sharma versus Sri Krishna Sinha and others, reported in All India Reporter 1959, Supreme Court, Supplementary 1, page number 806, the Honorable Supreme Court held that Article 105 and Article 194, being special provisions, would trump over Article 19, Clause 1, Subclause C, which is freedom of speech and expression, Your Lordship. Also, Your Lordship, these powers of legislature to punish for its contempt, including the breach of its privilege, is against modern democratic principles and will suppress democratic voices, Your Lordship. Your Lordship, in 2003, an arrest warrant was issued by the Tamil Nadu Assembly Speaker against a journalist of The Hindu for publishing an article using expressions incense, fumed, high-pitched tone because the members of the House conducted it as a breach of privilege, Your Lordship. This uncodified nature of privileges gave the legislature the power to interrupt this act as apologies, Your Lordship, to interrupt this act as breach, Your Lordship. The journalists were not even given an opportunity of being heard, Your Lordship, which is against the principles of natural justice, Your Lordship. Many cases and incidents have happened. Thus, the petitioner humbly submits that the power of legislature to punish for its contempt, including the breach of its privilege, is not essentially a judicial function which should be exercised by the legislature, taking into consideration about the uncodified nature of the powers, and that it is taking power over the fundamental freedoms, Your Lordship. Also, these powers are inconsistent with the modern democratic principles in Indus and need progressive reconstruction, Your Lordship. With this, the counsel for the petitioner humbly submits that the power of legislature to punish for its contempt, including the breach of its privilege, is not essentially a judicial function that has to be vested upon the legislature and is against democratic principles, Your Lordship. With Your Lordship's kind permission, may the counsel yield the floor to my co-counsel.
Yes, permitted.
Much obliged, Your Lordship.
May it please this Honorable Court, this is Counsel A11-2, appearing along with my co-counsel A11-1 and researcher. On behalf of the petitioner, In the case concerning Civil Rights Society and others versus Union of Inters, if your lordship kind permission, may the council directly move on to the contentions? If your lordship kind permission, may the council directly move on to the contentions?
Yes, please. Yes,
Much
please.
obliged, your
Carry on.
lordship.
Yeah.
The counsel for the petitioner has mainly two contentions to submit before the Honorable Court of Law. Firstly, the action of the Speaker or the Chairman of both the respective houses is violative of constitutional rights, namely legislative privilege and freedom of speech. And finally, the Punjab Prevention of Defacement of Property Act 1997 is unconstitutional and the FIR is registered against the said act against the unknown person and the members of the parliament is legal, your lordship. If your lordship can permission, may the council move on to the conditions. If your lordship can permission, may the council move on to the conditions.
Yes, yes, please, please,
Much
please.
obliged.
Please.
Much obliged, your lordship. The council would like to seek your attention to petitioner number 2, in this case, that Mr. Raman. Here, the petitioner humbly submits or humbly requested to draw your attention to Article 105, Clause 2 of the Constitution of Inters, which says that everything and anything said inside the parliament or inside the premise of the parliament, if it's not strictly pertain to the business of the house or if it's about the contempt, the member who spoke will get the immunity which is enshrined under Article 105, Clause 2 of the Constitution of India, your lordship. And the same was read in the case Tej Kiran versus N. Sanjeev Reddy, reported in All India Reporter, 1958, Criminal Law Journal 1055. And in that case, the court held the same thing which has been enshrined under Article 105, Clause 3. When a member inside the parliament can speak anything, which he can express anything according to his view, and he is clearly entitled to get the immunity. And in Surendra Modari versus Nabab Krishna Chowdhury, reported in All India Reporter, 1958, Journal 1328, in the same manner was prescribed in the same case about who has the immunity of the person who spoke inside the parliament. So the petitioner number 2, Mr. Raman, is clearly able to get the immunity as like others. And also, here the petitioner would like to point out or like to question, with due respect, we like to question the procedure established, or the procedure accepted by both these houses in case of petition number 1 and petition number 2, your lordship. Here, the actions initiated by both these speakers was adversely affected with their bias and arbitrary in nature, and that goes to a clear-cut violation.
Council,
Of
we
natural
have
justice,
to.
which is enshrined under Article 21, your
Yes,
lordship.
please
And
finish
in
off.
Kushbu
Finish off.
Kanayawal versus report in All
Your
India
time is
Report
up.
2010,
He
Supreme
has
Court
gone
case
to
page
2
number
minutes, sir.
1523,
2
the
minutes
court
left.
held that the free flow of opinion and idea is essential to a collective life of the citizen. Been from them is entered under Article 9 Clause 1, which is available for every citizen. And also in case of petition number 1, Mr. Robin, he is entitled to get the immunity of Section 135A, which has entered under Code of Civil Process 1908, which deals with the immunity of arrest and arrest and detention, which is matter dealing with the civil proceedings, and also for 15 days. In case of petition number 1, Mr. Robin, he is not entitled. He's clearly entitled to get the exception of the said rule 135 clause A, your lordship. And also the Punjab Prevention of Defacement of Property Act is clearly vague in nature. The section considered 2 clause A, 2 clause B, 2 clause D, and 2 clause E, which is considered as a pillar of the vital act, and it is considered there is no description about what is property or what property. There is no description about if it is the public property or private property. There is no description include the post cartoons. Mohinder Singh versus Chief Election Commission. The court held that an act which is not presenting an audio alter partem or not describing about the notice given to the affected party will be void ab initio, which means, Your Lordship, which should be void from the very beginning, and the said act is in violation of natural justice principle, which is enshrined under Article 21 of the Constitution, and also in violation, and also it comes under the ambit of vagueness, and Section 2 Clause D, it is describe about what is a cognizable offense, and there is no description about what all offense comes under the purview of this particular act. And also the petitioner would like to point out the authenticity of the allegation made against Mr. Robin and Mr. Raman. At the same time, a judicial intervention should be made in case of Mr. Raman and Robin, Your Lordship, because the action of the speaker was the action of the speakers in both sides was clearly affected with a bias and arbitrary.
Sorry, Counsel, your time is over.
He is entitled to get the immunity under enshrined under Article
Please finish.
135.
Please finish.
Your Lordship, kind permission, may the Council move to the prayer. Much obliged to Your Lordship, in the light of issues raised, arguments advanced, the authority cited, it is most humbly submitted that the court may please.
I am inviting Indore Institute of Law. Please, Counsel, you may leave now. Your time is over.
Much obliged to Your Lordship, and thank you for the opportunity.
This is the council for the response. The council seeks permission to address the bench as my lordship. Much obliged. I will be dealing with issue 1, 2, and 3.
Just a moment, Counsel. A11 Kerala Law Academy, you please switch off your mics. B team, B9, Indore Institute of Law. Only the speaker can open their mics. Carry on.
Dealing with first issues, and my co-counsel will be dealing with the fourth issue. The council seeks permission to start with the first issue. Much obliged.
You may proceed.
Much obliged. Issue first deals with the indemnity clause of special leave petition and the writ petition. It is humbly submitted before the Honorable Court that the present petitions by special leave petition and the writ petition are not maintainable in the court, as there was no violation of the fundamental right, nor any other rights were violated. The learned counsel of petitioners have given arguments for maintainability of writ petitions which were filed by Mr. Raman and Mr. Robin, and thus it can be inferred that they are not maintainable and they should be dismissed. The case which was mentioned is Pritham Singh versus the estate. The Supreme Court held that the court will not grant a special leave petition unless shown that exceptional and special circumstances exist, substantial and grave injustice has been done, and it is nowhere proved by petitioners that there was any grave injustice and nor is any exceptional and special circumstances. It was under the preview of the Constitution of the Indus, and hence this petition should not be maintainable. Moving on to issue number 6, about the power of the legislature to punish for the contempt, including the breach of its privilege, is essentially a judicial function or not. It is submitted before the Honorable Court that the power of the legislature to punish for contempt, including the breach of its privilege, is a judicial function. The rules of the procedure of a House somewhat curtail the member's freedom of speech, so that the freedom may not generate into an unrestrained license of speech. A member exceeds the limits imposed on his freedom by the Constitution or the rules of procedure of the House, he can be dealt with by the Speaker or the House itself. House of Parliament has the power to enforce discipline, to punish its members for their offending conduct in the House. A person found guilty of breach of privilege or contempt of House may be punished either by imprisonment or reprimand, or even by suspension or expulsion from the House, which was exercised by the chairman and speaker of respective houses against Mr. Raman and Mr. Robin. As in the case, Rajya Sabha expelled Subramanian Swamy on 15th November 1976 for conduct derogatory to the dignity of the House and its members and inconsistent with the standards which the House expects from its members. The Speaker of the House has the oath to conduct the parliamentary proceedings smoothly without any ruckus. But there was a ruckus on the floor of the lower house after the speech of Mr. Raman, and hence an action can be taken against him by the Speaker of the lower house. The rules 374 and 374A of the Rules of Procedure and Conduct of Business provides the Speaker the power to deal with recalcitrant members. The Speaker is empowered to place a member under suspicion. In the case of Sri Singhal versus Union of India, the court emphasized that there has to be a degree of proximity between the words spoken or expressed and the public disorder that takes place. In the case of Singh versus Speaker, the petitioner has been detained by the district listener under warrant issued over the signature of the Speaker of the Legislative Assembly. In this said case, the High Court held, dismissing the Keshav Singh's petition, that whether they had been contempt of the House or not in a particular situation is a matter exclusively for the House to decide, and the court would not go into the question of legality. As applying the situation to the present case, the court should not intervene into the legality of this case, and it should be dealt in the House according to the rules of procedure as established by the Parliament. And moving on to sub-issue 2 of first issue, yes, it is in tune with modern constitutional principle to entrust such powers with respective legislatures, as such powers helps in maintaining the idea of federalism, which is one of the basic features of Indus, and allows the legislature to take its decision solely without being influenced by the judiciary. The privileges which are given to the House of Parliament are necessarily must be inherent in them. Independent of any precedent, it is necessary that they should have the most complete personal security, able them freely to meet for the purpose of discharging their important functions, and also they should have the right of self-protection. In the case of Rajaram, this Honorable Speaker, Lok Sabha and others, the Supreme Court upheld the powers of the Parliament to expel its members from the House. The court observed that it has no jurisdiction to issue a writ petition, direction, or order which affects the internal affairs of the House. This was a current internal affair of the House, and the court should not intervene. The Council seeks permission to move on to issue number 6.
You may. Please.
Much obliged, Lordship. Issue 3rd deals with the action of Speaker or Chairman of the respective houses against Mr. Raman and Mr. Robin, respectively, is violative of constitutional rights of the legislature. It is humbly submitted before the Honorable Court that the action of a Speaker against Mr. Raman is not violative of freedom of speech and parliamentary privileges.
Council, your net is finished, I think. So your second partner may continue. If you people want to.
It's not violative of freedom of speech and parliamentary privileges. The lower house rule book specifies that MPs are required of parliamentary etiquette. It is the duty of the House to maintain order so that the House can function smoothly. Also, the businesses, the Speaker, if it is of the opinion that a conduct of is grossly disorderly, may direct such member to withdraw immediately from the House, and any member
Council, if your connection is not working properly,
So should we wait for them or should we disperse?
sir, their second partner may speak,
Yes, this is what I'm saying. Let him in.
or otherwise let them go.
Let them decide what they want to do.
Not audible. Your second person is, I am watching from here.
Your network is not supporting. Voice is shattering. Could you please rejoin?
Dr. Sahab, second person may speak in this regard.
Now my co-counsel will
The council seeks the permission to continue with the issue number 4.
Yeah, please. You have how much time he has left?
Much obliged, my
You have 3 to 4 minutes. You can finish the topic. You may.
It is humbly submitted before the Honorable Court that the present act in the question is constitutional. It is nowhere infringing any fundamental right of the citizens. It is enforced to restrict people from defacing any public property and to maintain the beauty of state public places. According to Section 2, this says that if any person tries to damage or spoil or disfigure the beauty of any public place, this act will amount to defacement. This doesn't infringe any fundamental right of any person, as it is nowhere mentioned in the Constitution that a person has a right to exploit the public property or to deface or interface with the beauty of any public property. Justice K.T. Thomas and senior advocate Fali Nariman to suggest changes to the law. The court opined that where persons, whether jointly or otherwise, are part of a protest which turns violent, result in damage to private or a public property, the persons who have caused the damage or were part of the protest are held liable and strictly liable for the damages so caused. According to Section 2B of the Act, property includes any land, building, hut, structure, wall, tree, fence, post, pole, or any other sections. Making all these practices making states look shabby, which can also hamper the tourism of the state, which result in the bad impact on the economy of the state. According to Article 19(1)(a) of the Constitution of Indus, it provides the freedom of speech and expression, but it doesn't include that for expressing opposition, the people have right to deface any public property. If a person infringes with the beauty of any public property, he will be dealt with under Prevention of the Damage to the Public Property Act 1984, which is a central act. And for the case of Punjab, it can be held also liable under the Punjab Prevention of Defacement of Property Act 1997. Now, the subclause 2 of the issue 4 is whether the FIR registered against the parliamentary and the peoples are legal or not. FIRs registered against the unknown people is legal, as whoever defaces any property in public view by writing or making with ink, chalk, paint, or any other material shall be punishable with imprisonment for a term of 6 months, or with a fine of 1,000 rupees, or with both.
Council, your time is over. Kind attention, Judge Sahab, Dr. Vijender Singh ji.
The council seeks the permission to continue with the prayer.
You may conclude in a minute or so, please.
Yes, sir.
Yeah.
Sir, please note down.
Wherefore, in the light of the facts presented, issues raised, argument advanced, and the authorities cited, it is most humbly prayed before the Honorable Supreme Court of Indus that it may be pleased to adjudge and declare that the writ petitions and the special leave petitions are not maintainable and hence should be dismissed. The power of the legislature to punish for the contempt, including the breach of privilege, is a judicial function, and it is in tune with the modern constitutional principles to entrust such powers with the respective legislature. The action of the Speaker, Chairman of the respective houses against Mr. Ramana and Mr. Robin, respectively, are not violative of constitutional rights. The Punjab Prevention of Defacement of Property Act 1997 is constitutional, and the registration of FIRs against unknown and members of Parliament under the Act is legal. The Honorable Supreme Court may be pleased to pass any order as it deems fit in the interest of justice, equity, and good conscience for this act of kindness. The respondent shall be duly bound forever.
Dr. Saab,
Okay.
we may take results over telephone, so we can leave now from here. And 2:45 we will meet for semi-final rounds. 2:45, sir.
Okay.
Right, sir. And Mr. Abhay Oja will also join you at 2:45.
Sure.
Thank you, Dr. Saab. Take your lunch. Sorry to take your whole day. You don't mind, please.
Perfectly fine. Chalo. Thank you.